This hearing is in the matter of case number CFI 064-2022 before Justice Wayne Morton. The claimant is represented by Clyde & Co. Lead counsel is Mr. Nicholas Craig, KC. The defendant is represented by Al Rashid and Partners. Lead counsel is Mr. Rupert Reed, KC, and Mr. Gregor Hogan.
Good, thank you. All right, now, Mr. Reed.
My Lord, good morning. You will have seen that there are two applications. The first is a stay application, which was made on the papers in view of the fact that the registry essentially rolled up the two applications, unless your lordship thinks there may be some reason to extend the period for writing judgment so that your lordship may have a first sight of the Court of Appeal judgment.
Well, that was exactly what I had in mind, Mr. Reed. It seems to me there are three options, and of course, Mr. Craig, I'll hear you on this in due course, but there are three options. One would be to stop and not do anything this morning and wait and see what the Court of Appeal says. The disadvantage of that is that you're all ready to present argument. Quite a lot of money has spent in preparation of that argument, and that money would be thrown away. The other alternative is to go ahead and then me deliver my view on all the issues in this application, some of which, at least one of which, overlaps quite significantly with the decision in the Court of Appeal. And that decision of the Court of Appeal could render the other issues redundant, depending upon which way it goes. So then the problem with that is that then the parties would arguably have to incur further costs. By then, if my decision was contrary to that of the Court of Appeal, they would then have to go on appeal themselves. And that would, again, be disadvantageous. So it seems to me that the most practical course is for me to hear all the argument on all the issues today and then reserve my decision until sometime after the Court of Appeal has delivered its decision. And then inviting, of course, the parties to put in any further submissions. I would imagine that they could all be done in writing after the decision of the Court of Appeal is delivered, and I could then deliver my decision. Now, Mr. Reid, what do you say to that course?
Well, my Lord, as I've intimated, that struck me as being a sensible solution in the circumstance. We would hope that we could deal with any new points arising in the Court of Appeal decision in writing, but I suppose the parties would be at liberty to make an application if they felt a further hearing were required.
Of course. Mr. Craig, what's your view on that approach?
Well, I think of you, I think I suggested in my skeleton argument that there's basically only one issue that turns on the question that's going to be determined by the Court of Appeal, which is the ambit of the jurisdiction agreement. It has nothing to do with the strikeout. And so, in a sense, one could determine and issue a judgment on the strikeout and reserve the decision in relation to jurisdiction pending that decision, which it seems to me is going to be, whichever way the Court of Appeal goes on that, is going to determine the jurisdiction question in this case.
Well, I'm just not 100% sure that there isn't any connection between those two. So, in other words, the things that the Court of Appeal might say in relation to jurisdiction, for example, there might be an issue of discretion arise, and they might say things in relation to discretion that could be relevant to other aspects of the case. So I'm just not sure that it is that it can definitely be segregated in that way. Not having, of course, been in the Court of Appeal on Monday. I don't know if you were, Mr. Craig, but
I was, and it's. I mean, the question in the Court of Appeal is literally the question of the construction of the jurisdiction clause which we have in this case. Yeah. And the argument was essentially that, I mean, which is being advanced in this case, is the effect of the insurance law and the alleged mandatory dispute resolution process, which cuts out any other dispute resolution process when you have an insurance claim. And I've detailed in our skeleton what we say about that and why we don't consider that's a good argument. But that is it.
Yes. Well, I mean, the other way of looking at it is that the decision of the Court of Appeal, if it goes one way on that point, will be decisive, and there will be nothing left to decide. And while I like writing judgments just for the sake of it, my time might be better spent doing other things. So that's another way of looking at it. As I say, I'll get the transcript, and that will be enable me to refresh memory. So I think the best, unless there's anything more you want to say, Mr. Reid, I think the best course is if we proceed that way. I'll hear argument on all issues today, will get transcript. Perhaps, Mr. Craig, you'll be aware, of course, when the decision of the Court of Appeal is delivered. If you could notify, Mr. Reid will be watching it too, I'm sure.
Mr. Hogan was also
Oh, Mr. Hogan was also there. All right. Oh, so the Dubai Club was there, were they? So. all right. Well, if then notify and then let me know. I'll invite submissions. Of course, it's possible you may even reach agreement, depending upon what the decision of the Court of Appeal is. But if you don't reach agreement, we can set a timetable for submissions and any application for further oral hearing after the decision of the Court of Appeal is delivered. Okay, back to you, Mr. Reid.
Lord, I'm grateful. My Lord, just before I start, as a matter of housekeeping, that various brickbats have been flying in various directions in relation to a number of matters, in particular, length of skeleton arguments, admission of new documents in file M, and the extent of submissions in witness statements. My Lord, we can spend the next half an hour debating those. I'm not sure that's a particularly productive use of our time. I do apologise for the length of our skeleton, but I hope that it's been helpful, and I hope that it's assisted in setting up relevant authorities.
Indeed. Well, I don't see much virtue in that. In relation to, for example, the admissibility of the paragraphs in the witness statement, we could debate all that, or I could simply take them as equivalent to submissions.
Lord,
is there any difficulty with that, Mr. Craig?
No, that's fine.
Thank you. Your picture seems to have frozen on my screen, Mr. Craig, but I can still hear you, so that's okay.
Sorry. Anyway. Hopefully it will come back to life shortly. Is it still frozen?
All right, back to you, Mr. Reid.
My Lord, you will have seen from our skeleton, essentially, in terms of the issue tree, our primary application is for a striking out or a setting aside of the claim on the basis that the DRC court doesn't have jurisdiction, essentially that the Sharjah court has exclusive jurisdiction. You have seen the way we put that argument as a matter of contractual intention, by reference to the regime, as I've described it, in the onshore UAE, Article 110 of the insurance law, and the effect of the CPC. The secondary application, if we're wrong on that, if the DIC court does have non-exclusive jurisdiction, is that the court should not exercise such jurisdiction as it has pursuant to principles of lis alibi pendens. And lastly, if lis alibi pendens isn't, as a matter of doctrinal DIC law, isn't available because it's part of the doctrine of foreign non-convenience, then we seek the exercise of the discretionary remedy, i.e. a strikeout on the basis of abuse of process. In terms of the core chronology, if I could just go through the
Yes.
key events, if you like. The accident itself was the 19th of September 2021. And then everything else is essentially 2022. So on the 13th of April, IPMR issues its complaint to the central bank, and that's obviously internally then referred to the IDRC, which is a committee within the central bank. On the 9th of August, UIC files its substantive defence in the complaint. On the 15th of August, the IDRC dismisses the insurance complaint. Almost immediately on the 22nd of August, IPMR files its claim before the Sharjah CFI. So the Sharjah proceedings are on foot by August of last year. And that's obviously a critical difference, we would say, certainly on lis alibi pendens from the Buhera case, which your Lordship will have read, where the matters in Sharjah were still proceeding through the IDRC. There were then various hearings in the Sharjah court. So there was a case management hearing on the 5th of September, and there was a case management hearing on the 20th of September, and essentially extensions of time were sought for powers of attorney and for the filing of a substantive defence. It appears that what was really going on behind the scenes was that UIC was gearing up to bring its own proceedings in the DIFC, and essentially without warning, that occurred on the 29th of September. On the 26th of October, IPR files a memo in the Sharjah proceedings. Your Lordship has that at 2013. It's badly translated as defence, but so this is M 2013. Does your Lordship have that?
Just looking for it. Yes, I have that.
And if I could scroll on to, so this is the substantive defence being filed in Sharjah by my client, IPMR. And if I could scroll on to 2025 and just pick up at the top of that page.
It's loading up a bit slowly, but keep talking and I'll get there.
Okay. Well, essentially, at the top of the page, first 5 lines, in its reliance on the provisions of Article 102 of the CPC, which stipulates ceasing of actions as suspension if the court considers suspension of a ruling until settlement of the case presented before DIFC, the defendant commits a fault against the understanding of law and violates its provisions. So, which reflects the fact that an application was made to suspend the Sharjah proceedings in favour of the DIFC proceedings. And we know that that stay application was rejected. And we know that not least because on the 30th of January, that's this Monday, the Sharjah court issued a preliminary ruling, and your lordship has that at page 2004.
Yes, I've got that. Thank you.
And there you see a heading, minutes of hearing, case number 30th of January before Judge Imam. And then critically, picking up at the bottom of that page, the court has decided before considering the merits and pleaded claims to appoint a committee of 3 experts, according to the experts list registered at the Ministry of Justice, consisting of 2 engineers of metal and gold refining, and the third of an insurance expert to be chaired by the oldest, the assignment of which, subsequent to perusal of papers and whatever exhibits may be submitted by both parties, as well as all the exchanged communications and writings, and move to the site of the incident, subject matter of lawsuit, in order to inspect the point and review the unloading of surveillance cameras at the site of the incident for identification of the following. So what is envisaged is those 3 experts will investigate all the documents and exhibits that have arisen out of the IDRC proceedings. They will view the exchanges and submissions. There'll be a site inspection. They will look at the camera evidence. The questions they will address are then enumerated over the following pages. If I could just pick up, my lord, at 2008.
Yes, I have that. Thank you.
In general, the committee has discussed the motions of both parties to the litigation and realisation of the defence. For the performance of the mandate, the committee may hear the testimony of the witnesses. Whoever's testimony is necessary to be heard without administering an oath. Committee is authorised to visit any entity and so on. And if I could just ask your lordship to read quickly what remains of that paragraph. Essentially, they're going to draw up a primary report, and they're going with a view which will then be presented to the court, and it will also produce a final comprehensive report. And then over page 209, you see the judgment, which is essentially the delegation to a committee of experts.
Yes.
So that's what's happening in Sharjah in terms of the proceedings that are on foot in Sharjah for the investigation of this claim. Now, my lord, in terms of the background, your lordship will be aware that the refinery is in Sharjah. It's in the airport-free zone, the safe zone. IPMR are refiners, and this is their gold refinery. That is why Sharjah is the home jurisdiction of IPMR. For your lordship's notes, there are various photos of the refinery, which is a fairly substantial site. They're at B78. I don't think we need to turn them up. They are in the Pioneer report, fairly substantial structures. The accident is described in Mr. Mary's first witness statement. Essentially, it's the breakage of a storage tank and the loss of a significant volume of gold solution, which was at the middle stage of the process. And your lordship will have seen Mr. Hogan's flowchart in terms of the process. And essentially, the gold solution is being stored in the middle of the process. There are 2 loss adjusters report that your lordship has in the court bundle. The first is the CTA, which is the insurer's loss adjuster who attended the scene on the day of the accident. If your lordship reads that report, you will see that there is nothing suspicious in terms of what they have uncovered. That's their preliminary report, I should say, on the 29th of October. So they've had a month by that stage to investigate the circumstances of the accident. If I could just take you briefly to a few points in that report, and I realise that the substantive points are not before your lordship, but there are a couple of points I do wish to bring out. If I could take your lordship to 256. So here, this is the summary. This is the summary, and essentially it is made clear that this is what follows is our detailed preliminary report, but that further inquiries are being made to clarify quantum, insured's liability, and other aspects of the circumstances of the loss. And then at 261, your lordship will see that at the bottom paragraph of page 261, that the CCTV coverage has been viewed, capturing the accident. And over page 262, second paragraph, the footage corroborates the circumstances surrounding the incident. So they see nothing surprising or curious or suspicious arising out of the CCTV footage. And then page 264, in terms of the further investigations, if I could just pick up after the photos at the bottom of page 264, halfway down the penultimate paragraph, in view of the value of the loss, it may be necessary to engage with a forensic accountant to assist in the quantification and verification of the loss sustained, depending on the nature of the proof of loss supplied. So it may be necessary. It's by no means suggested that it is necessary. And then lastly, just at 265, top of the page, you'll see the overall loss, 37.7 million US dollars, and then further inquiries at the bottom of that page. We're pursuing numerous further inquiries relating to, among other things, the insured's operations, background financial data to verify the scale of the operations, precise processes involved in the controls of the refining, who owned the lost gold, why the seal drain did not, and so there are a number of various further inquiries that are being pursued. But as I said, there's no cause for concern or no suspicion on the part of the loss adjuster. Your lordship also has the Pioneer report. That's the IPMR report. For your lordship's notes, that's the B62. Essentially, they have reviewed the documents and they concur that the amount of the loss is around 37. I think for various reasons they put it at 37.8, but they are very much in the same ballpark. In terms of the policies, there is an existing policy, all risk insurance, but that was specifically limited to stock. That's at B240. And this is the renewal on the 8th of August 2021, and you'll see the top of the table, property, all risk, insurance, and then halfway down the page, cover, all risks of accidental physical loss or damage to the properties mentioned below. And then the penultimate row on this table, in terms of the interest insured, your lordship will see on stock in trade, including gold and silver bullion, similar materials either in raw or finished form, 50 million. So the concern on the part of IPMR was that stock didn't cover gold when it was in process. And so what the gold refinery policy was about was essentially plugging a perceived gap in the policy, the property all risks insurance. And that's why we say it's essentially an extension of the existing property insurance. The gold refinery policy itself is at page 42, B42. And your lordship, your lordship will see the insured IPMR, the address is the Sharjah refinery, and then the interest being insured, essentially it's section A, any natural mineral, and then the sum insured, again, 60 million. So it's the same amount as the stock insurance. So it's essentially trying to cover the same mineral when it's in process, not just when it's in stock. And then at the bottom of the page, in terms of the what is being insured, section A, so the last paragraph, section A, all risks of physical loss or damage at named locations only. So it is limited contractually to the Sharjah location. And then over page 43, your lordship will see that there are various wordings that are attached, and there's various specific clauses that between insurers and reinsurers are well known, and therefore they can simply refer to them. And no doubt Mr. Craig will have something to say in terms of London wording and familiarity with that sort of wording. Going on to page 44, we have the jurisdiction clause, the choice of UAE law, and also the exclusive jurisdiction of the courts of the UAE. And then that's signed 14th of February 2021. And then at page 45, the cover, again, your lordship will see is by reference to the named location. And so that your lordship understands the scope, the ambit of the brewing, the dispute, the substantive dispute, UIC seeks to rely on various of the exclusions, including D, consequential loss, F, little Roman 1, inherent defect, J, any loss, damage, etc., arising from any kind of seepage. And they also seek to rely on various conditions, halfway down 46. So 1, due diligence, and 3, notice and proof of loss. So it is alleged that IPMR has failed to give adequate information, evidence, and cooperation. And then, most importantly, at 47 over page, your lordship sees condition as to misrepresentation and fraud. So if the insured has concealed or misrepresented any material fact, then the insurance shall become void. And what he said is that there was a misrepresentation as to the amount of gold that would be in process at any one time. And that was said to be a fraudulent presentation or a fraudulent concealment. So that's the scope, if you like. And then at 48, there's a further iteration of the choice of law and jurisdiction clause at condition 12, which I don't think adds to or varies the existing choice of law and jurisdiction clause. As I've said, in our submission, it's essentially an extension of the property insurance in that it looks to ensure the minerals, the gold, at the property as it is in process. This policy was identified through Shadid Re, who are Lloyd's brokers, interestingly, in Lebanon. So the idea that that you need to be English speaking or steeped in the common law to understand Lloyd's or London policies is perhaps undermined. The form is based on a Hiscox form, and your lordship has that at 477.
Yes, thank you.
And that's the general specie, and your lordship will see. So this is a policy designed to cover essentially specie or minerals. And at 479, you'll see the cover, and again, which is the wording essentially borrowed. The property described in the attached schedule is insured against physical loss and physical damage occurring during the period of insurance while at the named location. So again, based on the property, subject to following exclusions and conditions, then as one would expect, as we've seen. And in terms of the numbering, the HIS SP97, I believe to be Hiscox specie 1997. So this is a form of wording that's been around since 1997. Now, we say in terms of factual matrix or background against which one has to construe the intention of the parties, one needs to start with the insurance regime in the UAE. And as we've described in our skeleton, there is a very marked separation between the onshore and the offshore insurance industries. One starts, it's so profound, it starts with the UAE constitution itself. And we have that at I think we go straight to 881.
Well, Mr. Ed, is this submission going to the first point, that is the identical point that's going to be determined by the Court of Appeal, or does it have a broader application than that? Because I'm just wondering if there's any utility in addressing me on the issue that's going to be addressed by the Court of Appeal, because the Court of Appeal will decide, and I will be bound by whatever that decision is. So my view on the proper on the constructional point, which I understand you're now submitting precisely the point that was raised before the Court of Appeal on Monday, and if so, I just wonder what the point of it is. Because even if I was persuaded to your argument, the Court of Appeal takes a different view, there's nothing I can do about it.
One does see situations, my lord, where a judge accepts or acknowledges that he's bound by a decision of the Court of Appeal, but may express a view, a personal view, which to some extent may influence the parties in terms of whether they feel it necessary to take the matter on to the Court of Appeal. The Court of Appeal may take a view. It is likely that view will be compelling, but it is not outside the possibility that IPMR would take the view that actually that's wrong. Obviously, there would be a huge risk in terms of costs in their doing so.
Yes.
But they would, and that they may want to take the matter on to the Court of Appeal.
And hope that a differently constituted Court of Appeal might come to a different view.
My lord, yes. Well, there are numerous matters on which the Court of Appeal in the GFC has in fact decided that an earlier bench of the Court of Appeal got a matter wrong.
Not usually within months of each other, though.
No, that is true. My lord, I will.
Right. I'm not going to stop you. I just wonder though if we might not dwell too long on this, because
okay.
I think it's unlikely that I'm going to have to write reasons on this part of the judgment. But anyway.
My lord, yes. Well, my lord, you will have seen Article 121 of the UAE Constitution. Essentially, the federal government, that's noted 864, the federal government has exclusive jurisdiction over insurance. The insurance law is obviously the central piece of legislation in this. That is at J827. And the critical provision in terms of the separate regimes is Article 2. So this provision of this law shall apply to all insurance companies established in the state and to the foreign companies licensed. Primary insurers insuring risks in the onshore UAE are subject to the federal insurance law, but under sub-Article 2, the insurance law doesn't apply to the free zones, and will come. And if one then goes on to Article 24, you can see that the insurance and reinsurance shall be exercised in the state by any of the following persons who are licensed and registered with the authority. So this is again in terms of onshore insurance. Licensed by the authority, which is now essentially the central bank, and that is either a company established onshore or a licensed branch of a foreign insurance company. And then moving on to 68, and this is critical in terms of the distinction or the separation between the onshore and offshore. Article 68, insurance companies licensed to operate in free zones may not carry out directly an activity outside the zone, reinsurance accepted. So insurers in the free zones and here in the DFC can transact, can carry out reinsurance, or they can provide insurance of risks in the free zone, but not risks onshore. And I should say that is further reflected in Article 4 4 of the free zone law, which requires the free zones to limit their insurance activity to reinsurance. In terms of the Article 110, that is at 848. And obviously that is critically important. Your Lordship will see that 1C, should a dispute arise concerning any claim, the concerned party shall have the right to submit a written complaint to the authority, which will have the right to ask the company to provide clarification. So that essentially is a complaint by the insured to the now to the central bank, and under D, the complaint may request the dispute be referred to the committee, and that's the IDRC that's been established in 2019. And then 3, claims related to this disputes arising from the insurance policy activities and services may be only accepted after bringing these disputes before the committees. So an insured or insured or insurer cannot bring proceedings unless matters have first been raised before the IDRC. And then the concerned parties, so that's both sides, that's both the insurer and the insured, shall have the right to challenge the decisions of the committee before the competent court of first instance. So in terms of a challenge, and I should say that what is being done in the DIFC is not a challenge, so it can't be said to be pursuant to Article 110, because the IDRC decision went against IPMR, so that they're not challenging that decision. It's an entirely freestanding set of proceedings, but that challenge is before the competent court of first instance. And in order to determine what the competent court of first instance is, you need to look at the CPC. Now, there is a new 2022 CPC, which took effect in January of this year. We, of course, are dealing with the former CPC. That is at 1749.
Yes, thank you. I have that.
Yeah. And if I could go straight to Article 31, which is at 1757.
Yes, I've got that. Thank you.
So this is Article 31 is the default rule, essentially, that if you want to sue someone in the UAE, you sue them in their home court, the defendant's home court. So that's a fairly commonplace in most Arab civil procedural codes. And then at 31.5, in other than cases stipulated in Article 32 and Articles 34 to 39, it's possible to agree on the jurisdiction of a certain court to examine the dispute. So parties can opt into a particular jurisdiction, notwithstanding the CPC and the default defendant court jurisdiction, except in cases stipulated in those 32 and 34 to 39. And those articles include Article 37 for our purposes, which is over page at 1759. Article 37, in disputes related to claim of insurance value, the jurisdiction should be given to the court in whose circuit the domicile of the beneficiary or the location of the insured property. So that essentially turns on its head the default rule that it's you sue in the defendant's home court, where there's an insurance claim. It's essentially in the claimant's home court because the jurisdiction goes to the court in whose circuit the domicile of the beneficiary. So that's the insured may sue in their own home court or the location of the insured property. So the first limb is essentially consumer protection of the insured. The second is probably case management, because clearly the court where the insured property is likely to be better placed to consider the loss, for example, by way of site visit. Now, both of those in this case are Sharjah. So the home court of IPMR is the Sharjah court. and the insured property, as we've seen, is in Sharjah. And that non-exclusive jurisdiction is ordinarily at the election of the claimant, which is in most cases the insured. Now, I don't think we need to look at the IDRC complaint itself. We have in the bundles various substantive arguments as they were raised by UIC. We have that at 1575, a submission of the 21st of July 2022. We have a further submission from UIC on the 9th of August 2022, essentially raising points by reference to the provisions in the policy that we've looked at. From the perspective of IPMR, the requests for information and documents and the inquiries were proliferating months after the accident. And that's why the IDRC complaint was brought. That, Your Lordship, has at 267. The full substantive memo is at 1628. I don't think we need to go through, but I should say there is no suggestion at any point in the IDRC complaint, in any written document, that the central bank or the IDRC lacked jurisdiction, or indeed that the DIFC courts had jurisdiction and or would be the appropriate forum. And as Your Lordship will have read in the witness statements, the IDRC dismissed the complaint. The dismissal is at B55. There is a light attempt on the part of UIC in their evidence to suggest that there was actually a consideration of the evidence and that the evidence was of the claim was insufficient. On any reading of the IDRC's decision, in my submission, it's entirely clear that what they lacked was the technical expert report. That is essentially the pioneer report, which Your Lordship has in the bundle. Clearly, the work had been done, but there was a failure to submit by reason of a technical issue. And essentially, it is a formal technical rejection of the complaint by reference to the failure to file the expert's report. In any event, that then permits IPMR to make its Article 110 challenge in the Sharjah courts. Your Lordship has the challenge document, if you like, which was filed on the 22nd of August, B138 or C551. In one, it's called a contestation, and another, an appeal. But that conceals the real nature of the exercise, which is essentially a de novo review. It is not going to be a question as to whether the court was right. It's not going to be narrowly confined to an inquiry as to whether the IDRC was right to dismiss the claim by reason of the delayed filing of the expert's report. There is no hint in the early stages, certainly until October, of any issue as to jurisdiction. And I mentioned in the chronology those three hearings, so the case management hearing in September, the two case management hearings in September, and the preliminary ruling on Monday, which we've looked at, where the court determined to appoint a committee of 3 experts with broad powers of inquiry. And as I say, those proceedings are now well underway. An application appears to have been made to stay the Sharjah proceedings, but the Sharjah court is proceeding nonetheless. The DIFC proceedings were brought on the 29th of September. They are at A3. I don't think we need to turn it up. Essentially, they set out the defences to the indemnity claim. And as Your Lordship have seen, there are allegations of fraudulent misrepresentation and fraudulent concealment. And that seems to be at the heart of the dispute. And clearly the underlying suggestion, much of what UIC says, is that the Sharjah courts wouldn't be competent to assess, to sit on a complex case raising serious issues of fraudulent misrepresentation and concealment. And the remedy sought is a negative declaration. From the start, IPMR contested jurisdiction, and the acknowledgement of service is at A21, and then the application notice in this application is at B23. Now, the legal principles appear to be largely a matter of common ground between the parties. Essentially, it's accepted that the issue is one of contractual construction, and the issue is whether there has been an opt-in to DIFC jurisdiction under 5A2. And your lordship has that. I'm sure your lordship is familiar with 5A2. I think your lordship has sat on enough decisions.
Always seem to like about in the DIFC court is jurisdiction. So anyway.
Well, it was even worse in the early days, my lord. For the first 5 years, it was nothing but. And we were quite excited about the idea of actually having a substantive trial. So 5A2, and of course that is a product of the 2011 amendment, and there are some wrinkles that arise because some of the early cases, including Tallinn, refer to 5A2, which was an opting out provision when there was no opt-in, so there has to be some issue sometime with the authorities pre 2011. But essentially, the CFI may hear and determine, and I've always read that to suggest that the court is not required to exercise its jurisdiction, and that's essentially the Armco jurisprudence, that there may be situations where the court does not exercise jurisdiction, even though it has it pursuant to a jurisdiction agreement. And there is this additional wording where the agreement is pursuant to specific, clear and express provisions. And there is a degree of learning in terms of what that means. Your lordship will have seen the decision in Suntec, which is a J 1258. And if I could go straight to 1265.
Yeah.
Paragraph 24. At the end of the day, it would be nonsensical to conclude that the parties had agreed to the jurisdiction of the DIFC courts as opposed to the onshore courts, but that the words were not sufficiently specific, clear or expressed to amount to an agreement for the purposes of Article 5A2 of the amended JAL, with the result that the matter would have to be determined in the onshore courts. And then if I could just pick up the last two sentences.
I think I followed this in gold, didn't I? Gold?
I think, yes, I think your lordship did, although curiously, I mean, the position that Mr. Justice Cook gets to is that these words don't really add very much. The assumption at the time, there was guidance circulating at the time that if you wanted DIFC court, you should specify DIFC court in terms. And there was some speculation as to whether these words meant that you really needed to make it clear by spelling out DIFC court. And what Justice Cook is essentially saying here is, no, you can achieve specific, clear and express opting in, even if you have to do so by way of contractual construction, or by looking at all the surrounding circumstances. And many read this judgment as being essentially that those words are otious. They really didn't add very much. It didn't matter that you were doing so, but you were doing so by way of a process of, if you were construing it to be DIFC courts, where the wording was in terms of courts of Dubai, courts of UAE, and if you were doing that by way of a process of construction, as far as Justice Cook was concerned, that was fine. So many considered that he was essentially reading out those words, whereas actually the later cases, in particular Goal in the Court of Appeal, Mr. Justice French, I think it is, suggests that the words do actually have some importance, and he asked the question again, are these words sufficiently clear, specific, clear, and express? So that's the view in Suntec. So the court can interpret the wording courts of Dubai, courts of UAE as being either exclusively the courts of one or the other, or potentially the courts of both. And we'll see from the cases that the emerging position seems to be that the default position or the ordinary reading is that it should be both. And you get to that result by essentially taking a constitutional view. So you say that the DFC courts are established pursuant to the Constitution, federal law, and DFC, essentially a nest of statutory provision, or by taking a locational approach, which is the courts of DFC happen to sit in the UAE, and therefore they are UAE courts. There is a view that that's counterintuitive, because your lordship would be aware that within the UAE, when one refers to UAE law or the UAE courts or the Dubai courts, colloquially one is usually referring to the onshore courts. So that position as to what the default position or the ordinary meaning is in itself possibly debatable. In Suntec, the judge considered that he was considering whether it was one jurisdiction in contradistinction to the other, and we get that from 1262. So picking up a paragraph, one has the escrow agreement at paragraph 9, which gives jurisdiction for courts of Dubai, and then at paragraph 10, this is not on its face an exclusive jurisdiction clause, but for present purposes doesn't appear to be mere of significance. Because the courts of DFC and the onshore Dubai operate in the same country, the parties may be taken to have chosen one system or another, and by doing so confer jurisdiction on that system in contradistinction to the other. If the word to be taken as a choice of the jurisdiction of the onshore Dubai courts under Article 13 of Dubai Law 10 of 2005, effect should be given to that choice, notwithstanding the existence of jurisdiction under Article 5A1 of the amended JAV. Even if the injunction granted by the onshore courts is only capable of enforcement indirectly in the court by recognition of the DFC courts. So he there is suggesting that the exercise for the court is to identify one or the other. So that supposes that the jurisdiction is exclusive, notwithstanding the arguably non-exclusive language of 5A2 itself. And that is consistent with many of the earlier cases which are dealing with opt-out, where essentially the court is saying, is a reference to the courts of Dubai or the courts of UAE exclusively a reference to the onshore courts, i.e. consistent with the colloquial meaning of those terms. And again, there the court essentially sees a switch. So they see, well, we have to decide, is it this or that? Is it one or the other in contradistinction to each other? And that, if you like, is in my submission, the Suntec approach. And what you then do under that approach is you look at the surrounding circumstances. So if we look here, and paragraph 11, essentially by reference to Tallinn and Corinth Pipeworks, identifies the need to look at the surrounding circumstances to ascertain the parties' intention as to which of the two they had in mind. And then in paragraph 17, you see essentially a reference to the fact that the escrow agreement was for share certificates to be held in escrow in the DIFC offices of the DIFC entity within Al Tamimi, and indeed that the escrow agreement was pursuant to a related agreement which provided for LCIA arbitration in Singapore, and the feel of the agreement was, the global agreement, if you like, was wholly common law, and in those circumstances it was found that the intention was that courts of Dubai should be the DIFC courts, in the national bonds in Tallinn, so that's an earlier case which we have at 1711.
I've got that, thank you.
And the issue there is whether it was an agreement to confer jurisdiction on the non-DIFC courts, whether it was therefore an opt-out agreement. And again, the court considered this to be an exercise in construction in the circumstances. And at paragraph 42, one sees the reasoning of the court. So they point out that there's a provision in the Murabaha agreement, it's a tripartite agreement, which provides in respect of appropriate forum, so the buyer irrevocably waives any objection which it might now or hereafter have the courts referred to, being nominated the forum to hear and to terminate proceedings, is not a convenient or appropriate forum. So the court says, well, the concern must be that any claim would be in a common law court, which would have regard to the foreign non-convenience doctrine. And so the supposition is that that argument would be being raised in a common law court. So the parties therefore must have had in mind that this was that it was a common law court, i.e., this the DIFC court. And then in paragraph 46, there's reference to the fact that the property in the agreement was located in the DIFC, and that the function of that agreement was to regulate the relationship between the beneficiaries under the trust. And they say, therefore, again, that is a pointer, a circumstantial pointer to DIFC jurisdiction, to the courts of Dubai, the DIFC courts being the relevant courts of Dubai. And one has that at paragraph 55. If that conclusion is correct, we believe that the analysis of the meaning of courts of Dubai in clause 14.1 should clearly take into account that the Murabaha agreement was governed by the law of the DIFC to include trust law. And as we've already indicated, the intrinsic improbability of the parties agreeing to refer disputes to the non-DIFC Dubai courts when the contract from which disputes could be expected to arise was governed by DIFC law. And that's a point that I think your lordship picked up at first instance in Goal, in terms of DIFC law being a major pull into the DIFC courts. The more recent cases have tended towards a non-exclusive jurisdiction approach, i.e. the ordinary understanding is that courts of Dubai, courts of the UAE, includes both the DFC and the non-DFC courts. We have that in IGPL, which is at, and if I can go straight to 1066.
Yes, I have that. Thank you.
And if I can just pick up at 138. For the purposes set out in 125 to 137 above, we find the ordinary meaning of the phrase Dubai courts must include all the courts and judicial committees formed within the territory of Dubai and established by the Emirates legislation, regardless of whether these courts exercise separate jurisdictions. We also do not accept IGPL's argument that the phrase courts of UAE was intended to refer specifically to the UAE Federal Judicial Authority. And then picking up at the bottom of the page at 143, as a practical matter, it's more conceivable that the meaning of courts of the UAE under the agreements was intended to cover all courts located within the territory of the UAE, so taking a locational approach. This includes all courts within Dubai, which in turn includes the DIFC courts. And then at 145 over page, finally, and in any event, we also find the choice of court clauses in the agreements properly construed afford SCB Standard Chartered the right to elect to sue in any court of its choice. For convenience, the relevant provisions under the agreement are reproduced below. And just picking up that this is a point which arises on lis alibi pendens. If you are going to find that the courts of onshore and the offshore courts both have non-exclusive jurisdiction, given a broad construction of courts of UAE, there then has to be some controlling mechanism for how you prevent a proliferation of claims in both. And the suggestion here by the Court of Appeal in IGPL is that the claimant can elect to sue in a court of its choice. And there's some suggestion in the concept of election that once one party has has engaged one jurisdiction, that is essentially becomes the jurisdiction. Certainly as far as that party is concerned. And I would suggest more broadly. I won't take you to your lordship's decision in Goal. Your lordship has that decision at J901. The approach taken by the court was essentially one of an objective assessment of common intention. So it's not about what the parties subjectively thought, it's looking at the parties objectively in the circumstances of the case. And as your lordship outlined at paragraphs 31 and 32, there is a mixture of text and context in seeking to assess the intention of the parties. And then Goal trundled to the Court of Appeal, and that essentially followed the IGPL approach So the courts of Dubai ordinarily means both, unless context or purpose points in a different direction. There is some introduction of new language, and this is what I mentioned in terms of clear, precise, and express, the proviso, if you like, in 5A2. So if one goes to page 932, so just picking up at paragraph 89, second sentence, when the terms the courts of Dubai is used in a contract, the ordinary meaning, absent context and purpose pointing in a different direction, refers to all of the courts of Dubai. So that's the IGPL position. And then the final sentence of this paragraph, where the jurisdiction of a relevant court is required by law to be enlivened by the agreement of the parties, as in Article 5A2, it is still able to be embraced within the ordinary meaning of the courts of Dubai. And I think enlivened is a concept that Mr. Justice French has used in other cases in terms of jurisdiction, maybe a matter of Australian jurisprudence. But sometimes it's used in the context of engaging a jurisdiction, and sometimes it's used as here to mean something else. I think what it means here is clear from 90, because he says there are two questions to be determined. The first is, what is the proper construction of the choice of court provision in the guarantees? And the second, if properly construed, the choice of the court provision confers jurisdiction on the DIFC courts, whether exclusively or on all relevant Dubai courts. It is effective to enliven the jurisdiction of the DIFC CFI pursuant to Article 5A2. And I think what emerges is that the reference to 5A2 then picks up the proviso. That's the clear, specific, clear, precise, and express. And we get that from, go on to page, over page 933, paragraph 100. It must be emphasized, of course, that the construction of terms such as courts of Dubai and the courts of the Emirate will depend on the proper context. The history of the transaction in issue in this case is central to the constructional conclusion. It does not answer the question of construction of every case in which the term courts of Dubai is used. As the DFC Courts Practice number 1 of 2015 implies, parties wishing to provide for the jurisdiction of DFC courts under 5A2 would be well advised to use that terminology. So essentially, he's setting against the default or the ordinary position. He's reminding us that it is still an issue of construction, and that parties should specify DFC if that's what they want. And the position is further clarified in the Labika case of the decision of the Court of Appeal, which your Lordship has at 935, which essentially followed Goal, and I think is probably also a decision by Mr. Justice French. And if I could pick up at 942. Picking up at
Thank you.
Picking up at paragraph 40, the approach outlined in Goal leaves open the question whether, in the particular circumstance of this case, reference to the courts of Dubai is sufficient to enliven the jurisdiction conferred by Article 5A2 of the JAL. So we're back to this concept of enlivened jurisdiction. It's clear from what is said in Goal that the ordinary meaning of the term courts of Dubai is capable of meeting the requirement of Article 5A2 for a specific, clear, and express provision. So it's capable of meeting the condition in the requirement. And then picking up at 42, in this case, there are no surrounding circumstances to support a construction of the term courts of Dubai in the contract, which would not apply their ordinary meaning, which includes the DIFC court. Consistently with Goal, we hold that where the parties agree to repose jurisdiction in the courts of Dubai, then absent constructional indication of the contrary, whether from the text of the contract or the surrounding circumstance, the terms will be interpreted as sufficiently specific, clear, and express for the purposes of Article 5A2 JAL to confer jurisdiction on the DFC CFI. The terms specific, clear, and express each involve judgment of degree. What is sufficiently specific, what is sufficiently clear, and what level of detail is required to meet the requirement of express. So in a way, the inquiry that Mr. Justice Cook quietly disposed of in Suntec is very much resurrected and is very much alive and kicking in the mind of the Court of Appeal in the Labika decision, i.e. the court has to read the proviso carefully and consider whether the jurisdiction is enlivened by reason of the relevant choice of jurisdiction being sufficiently specific, clear, and express. Now, applying the legal principles in this case, we say there is not a single DIC connecting factor. It is extraordinary. Most business transactions in Dubai, if one looks hard enough, one can find a factor connecting to the DIC somewhere. Every detail of this case is onshore. IPMR is incorporated in Abu Dhabi. Its gold refinery is in Sharjah. Its gold refining operations are in Sharjah. The insurer is an Ajman company regulated by the UAE Central Bank and has a branch office in Sharjah. The insured risk is gold in process at the insured property in Sharjah. The parties themselves clearly believed they were subject to onshore regulation and the onshore dispute regime. That is entirely consistent with the distinction we say between the onshore insurance regime under the federal insurance law and the free zone, the DIFC insurance regime, which limits activities in the DIFC to reinsurance and the insurance of offshore risks. The parties were clearly following the onshore dispute resolution procedure. So we have seen the IDRC complaint and then a challenge of the decision of the IDRC to the competent court, and the competent court under the CPC, under the provisions in respect of insurance, reversing the ordinary position is the claimant, the insured's home jurisdiction, and also the place of the insured property. And that's exactly what happened in this case. It's also exactly what the parties would have anticipated, because they were aware, both parties were aware of the onshore regime. They would have been aware of the CPC and its inversion of the defendant home court normal rule. This is a matter, we would say that the regime as operated onshore is an expression of public policy. The insured is intended to have a cheap investigation procedure under the IDRC without necessarily incurring at that stage significant legal costs. And in terms of jurisdiction under the CPC, the insured has access to its home court. There is no provision for opting out by way of agreement. We've seen that in the CPC. We also see that in the board decision 33, which essentially is like a statutory instrument implementing Article 110 and implementing the IDRCs. That is at 858. And if I could pick up at Article 1, the definitions. So federal law, that's the insurance law and the Establishment Insurance Authority, that's the law. The regulations are the regulations of the law. Company is the insurance company, and then insurance disputes is the disputes arising from the complaints of the insured beneficiaries and concerned affected parties against the company. So again, that picks up the point that this is a regime where the insured it's only the insured that's able to bring complaints to the IDRC. And just picking up actually at the top of page 859, that's 2 sub-article 4, in fulfilling its operations, the committee shall be entitled to review papers, documents, records, and all evidence, and take all actions it may deem appropriate without adhering to the civil procedure law, the law and the regulation of the legal profession, and official working hours. So essentially, the IDRC has very broad investigative powers in terms of reviewing documents and evidence and taking such actions as it deems appropriate. And then going halfway down the page to Article 5, the committee, let's say the IDRC, shall not be competent to, and then 2, insurance disputes pending before the courts before the regulation goes into effect in any instance of litigation. So the exception to the requirement to go to the IDRC exists only in respect of disputes that are already pending, that are already going through the onshore UAE courts. And 3, the insurance disputes that are subject to an arbitration clause. So you can opt out of the IDRC by provision of an arbitration clause, and you can opt out, or deemed to have opted out, in circumstances where there are existing proceedings. But there is no provision there for exclusive jurisdiction clauses that take an onshore insurance dispute arising out of a complaint out of the regime, the dispute resolution regime, which requires an initial complaint by the insured to the IDRC. And I think that's all I need from, so as I say, there's no reference in Article 5 to opting into any other jurisdiction, and essentially opting out of the IDRC, the insurance law regime. Now, the courts of the UAE has to be objectively construed in terms of what a reasonable business in the position of IPMR, the UIC, would have understood in all the circumstances. And we say, when you look at that regulatory regime, the mandatory recourse by the insured to the IDRC, the challenge from that decision of the RDC to a competent court in circumstances where the competent court is the insured's home court or the location of the insured risk. We say that against that background, the proper construction of courts of the UAE is the courts of Sharjah. That's what the parties would have intended, because that's what they would have clearly understood as a matter of the local onshore regime. So as a matter of UAE law, that would be the result. Your Lordship might then say, well, what is the jurisdiction agreement doing if the CPC would achieve that anyway? Well, that we would say is right as a matter of UAE law, but as a matter of non-UAE law, when you're in the offshore jurisdictions, the CPC has no effect and doesn't bind. So the effect of the jurisdiction agreement is essentially to produce the same result, even if the matter is being considered by an offshore court such as the DIFC court. So to that extent, the jurisdiction agreement still has value in selecting Sharjah consistently with the position under the CPC, which is what would be enforced and applied in the onshore local courts. And we say it is highly unlikely that the parties intended that they would produce a different result to that under the UAE, the non to UAE law, to onshore UAE law. What is then said against us by UIC, the insurer, is that you need to look at other connecting factors, which militate in favour of the DIFC court having jurisdiction. There's a fundamental problem of all of that line of argument, which is that they are alleging a non-exclusive jurisdiction. So they are alleging that not only the DIFC courts, but also the onshore courts have jurisdiction. So to argue that the non-DIFC courts, for example, are not competent to deal with complex fraud cases doesn't work, because if that was the case, then what they would have done, or what they logically would have done, would be to specify the exclusive jurisdiction of the DIFC courts, which they, on their own case, didn't do. Putting aside that fundamental problem, there are essentially two arguments. Firstly, that the policy is in English and uses London market wording, which I would obviously accept. We say that the London market clauses are widely used globally, and indeed this provision was provided by a Lloyd's broker based in Lebanon, a Beirut company. And Dr. Al-Rashid, in her second statement, describes the familiarity to UA judges of the English form clauses. I should say that your Lordship will be aware there's not a huge body of insurance decisions by the DIFC court, and that is a result of this division, if you like, between primary insurance onshore, subject to the jurisdiction of the onshore UAE courts, and the limited practice licensing of reinsurance and reinsurance of onshore risks in the DIFC, I think Allianz against and Al-Ain is probably the major insurance case. That is a reinsurance case. Before Buhera, I'm unaware of any significant decisions as to coverage or on insurance claims. Notwithstanding that, your lordship will be aware that there are some very distinguished common law expat insurance lawyers in Dubai. So Kennedy's, Clyde's, Holman Phoenix, and what the insurance teams in these firms are essentially doing is onshore insurance work that is being dealt with in the onshore courts. So they are essentially doing insurance work, working hand in hand with onshore local lawyers in dealing in transacting onshore litigation in the onshore courts, which in my submission undermines the second point, which is that only the DFC court, or the DFC court is the more suitable forum, and we're slipping into this language of foreign convenience, is the more suitable forum for complex disputes. Dr. Al-Rashid's evidence in her second statement is very much in terms of her experience of high value and complex disputes. And if this court, or the DFC court generally, were to find that the onshore courts did not have suitable experience or capability, that would raise a very real issue in my submission of comity. And similarly, an argument that that UIC has been deprived of a legitimate juridical advantage, the argument made by Mr. Beswetherick, would raise significant issues of comity. And in fact, we have seen on the facts of the hearing on Monday at M 2004 that experts have been appointed, specialist experts, experts in metal refining, experts in insurance, as a committee of 3 experts. And again, Dr. Al-Rashid gives her evidence at paragraphs 42 and 40.3 of her statement of her experience in terms of the appointment of experts as required in onshore insurance litigation. I do have to deal head on, if you like, with the points taken by Mr. Justice Giles in the Buhera decision. I don't know if your lordship's had the opportunity to read that.
Yes, I have.
I'm grateful. It's a slightly bizarre case. It's a case of a vessel that disappeared and then reappeared in the service of the Iranian Navy. Essentially, Justice Giles followed the analysis in Gul, Labika and IGPL. That's to say, courts of Dubai, UAE ordinarily means both onshore and offshore courts. Insofar as Mr. Hogan and his leader raised various contextual factors, he was unimpressed. Sorry, just Mr. Hogan on his own raised contextual factors. Mr. Justice Giles was unimpressed. He said that was the whole point of an opt-in, was to escape from the context. And in my submission, ignored the fact that context is a very important part of contractual construction. He was unimpressed by the separation of the onshore regime, and in my submission, this is where his judgment goes seriously awry. He suggested that the separation of onshore and offshore business had no bearing on the hearings of insurance disputes, whereas actually what one sees is not just a business that's separated in terms of what business can be done onshore and offshore. The dispute resolution, for first of all, the regulation, but then the dispute resolution regimes are entirely separate. And when one looks at the detail, one cannot simply choose what the competent court is by way of a jurisdiction agreement. And in my submission, he was unduly weighed, having dismissed context insofar as Mr. Hogan was raising it. He then seemed entirely happy to rely on context in terms of the parties wanting English language and familiarity with English policy wordings. And there is in my submission, an absence of analysis of the insurance law and the CPC as part of the background in the exercise of construction. And it was only in considering abuse of process, right at the tail end of his judgment, where he looks at Article 110, and he suggests that dispute resolution applies only to claims by the insured. So he suggests that Article 10 is a partial regime that applies only to the insured. And in my submission, the obvious conclusion that he should have drawn was that UAE law doesn't provide for a negative declaration. Therefore, it has a preclusive effect. It prevents the insurer bringing a claim before the IDRC. So to that extent, it is for the benefit of the insured. But the conclusion and that in my submission would have been the correct inference, but he instead concluded that the statutory regime only applies to the claim by the insured. So it's only, I think, in his terms, it didn't cover the field, which means on his reading, therefore, that the insurer was entirely outside the regime and could do what they liked and could go straight to court. Now, that would have an extraordinary effect, because essentially the IDRC regime, which is intended to be for the benefit of the insured, would hobble the insured, because the insured would be bogged down in the IDRC, whereas the insurer could just step round the entire process, go straight to the court of their choice, and the insurer would then be given the procedural advantage over the insured. Now, that as a matter of UAE public policy simply makes no sense. It's not a conclusion which is compelling in any sense. So we say that the IDRC and statutory procedures apply to all claims under insurance policies, and the competent court therefore has to be determined under the CPC. That's the insured's home court, or the short court where the property is located, and that, as we say, is Sharjah. We say the parties would clearly have understood that, and to that extent would have intended it, objectively speaking. So that's essentially our submission on construction, my lord. So now moving on to the second. So I'm very grateful for your lordship's indulgence. I hope, even if it's just provides some background to an understanding of the Court of Appeal's eventual decision, I hope it was.
Thank you. Thank you.
Helpful. So, if your lordship determines, pursuant to the decision of the Court of Appeal, that UAE courts should be construed as any courts within the UAE, that, in our submission, raises the following inquiry as to how the exercise of that jurisdiction by relevant courts is to be controlled. Now, there are obviously various discretionary grounds, and Mr. Craig will no doubt in his submissions correct me if I'm wrong, but my understanding is the Court of Appeal was very interested in the issue of the discretionary remedies. And those historically would include, as a matter of general common law, foreign non-convenience. They may include to the Armco jurisdiction, so the court doesn't have to give effect to a jurisdiction agreement. That was obviously an anti-suit case, but it applies similarly in terms of staying your own proceedings. And we say lis alibi pendens is also the basis for a discretionary remedy in terms of the court not exercising jurisdiction that it hypothetically would be found to have. Your lordship will be aware that foreign non-convenience has been ruled out and was ruled out in IGPL as a doctrine that applies to allocate jurisdiction as between different courts in Dubai, or indeed different courts within the wider UAE. Your lordship has IGPL at 1040. If I could take you briefly through the high points. Essentially, there are a number of reasons for excluding.
Sorry, what was that page number again, Mr. Reid?
Sorry, J1040, 1040.
Thank you.
Essentially, there are a number of reasons why why foreign non-convenience should be excluded within the UAE. These are canvassed by Chief Justice Huang in that decision. Firstly, by reference to the Allianz decision, paragraph 162, to apply foreign non-convenience would need to be clarity through clear policy. So I think the suggestion is made that foreign non-convenience doesn't provide the requisite degree of clarity. It provides a very broad jurisdiction of the court to, or discretion of the court to determine the most appropriate court. Then he identifies from the decision of the Court of First Instance in the IGPL decision, which was a decision of I can't. It was the CFI decided that there would be a need for commonality. So, Mr. Justice David Steele, from memory, that there would be a need for commonality of approach. So the idea is, well, if we can't apply foreign non-convenience to disclaim jurisdiction, if the onshore courts aren't doing it because they don't have a doctrine of foreign non-convenience, essentially a requirement of reciprocity. And linked to that in the reasoning of Justice David Steele in the CFI was the idea that if you apply foreign non-convenience, there's a risk that the DIFC court doesn't exercise jurisdiction, and then that the onshore court finds that it doesn't have jurisdiction, and you therefore create a void, a jurisdictional void. And though that reasoning, or those reasons, are canvassed by Chief Justice Wang in IGPL, the reason that he found persuasive was the exclusive role of the Union Supreme Court. And if we pick that up at 186 in the judgment.
Yes, I got that. Thank you.
Sorry, I'm just going. So it's not disputed by the parties. The power to determine jurisdictional conflicts is vested in the Union Supreme Court under Article 99 of the UA Constitution, which provides as follows, and then picking up at 189. Once it's appreciated that power to determine the appropriateness of a UA court's assumption of jurisdiction relative to other UA courts rests exclusively with the USC, it cannot be persuasively argued that DFT courts have any power to determine the same question by applying the foreign non-convenience doctrine. Doing so would amount to a usurpation of the USC's constitutional function. And then picking up at 191, point is that the power to determine jurisdictional conflicts is absolutely exclusively vested in the USC under the UAE's constitution, and is therefore removed from this court's power under all circumstances. And then picking up at 195, in our view, the manner in which IGPL has framed the problem is apt to mislead and distracts from its true complaint. It's incorrect that DRC courts can, with abandon, exercise exorbitant jurisdiction. The reason why the FNC doctrine does not apply in such cases is precisely because the UAE has already instated a solution, albeit a different one from applying the foreign non-convenience doctrine to the problem, by empowering the USC to resolve jurisdictional conflicts pursuant to Article 99 of the UAE Constitution. And then IGPL's real difficulty, therefore, lies in the inability to invoke the USC's jurisdiction to resolve a jurisdictional conflict before one is crystallized. Yet a defendant in IGPL's shoes is not without a remedy. Such a defendant could commence an action in the alternative UAE court, seeking from that court a judgment or declaration which has jurisdiction to hear the dispute. Once a judgment or declaration of that effect is obtained from the alternative UAE court, the USC would be empowered to resolve the jurisdictional conflict. This is a slightly more tortuous route than the immediate application of the FNC doctrine by the DFC courts, but the resulting inconvenience does not rise to the level of injustice, so the defendant cannot be expected to pursue that route. That is, in fact, what IGPL has done, although the charge action judgment now makes clear that IGPL's efforts have not yielded any results in its favour. And then just lastly, 196. The necessity of pursuing the course of action I've just described is not peculiar to situations where jurisdiction is assumed by the DFC courts. It is inherent to the UAE's legal system and can arise whenever several of the UAE's courts are concurrently seized of a matter under the applicable provisions of the CPC. Accordingly, any convenience that a defendant is put to by the inappropriate exercise jurisdiction by one UAE court relative to another UAE court is, in the words of His Excellency Justice Ali Al-Madni in Alliance, a risk that both parties brought onto themselves when failing to agree on jurisdiction clause in a sophisticated contract, or even to reach agreement at any stage after the dispute had arisen, knowing full well the legal system in place at the UAE. So essentially saying the Constitution says that if there's a direct conflict of jurisdiction, that is a matter for the Union Supreme Court, and by implication, you therefore don't need foreign non-convenience. So the constitutional solution in terms of the USC is therefore squeezes out, if you like, foreign non-convenience. I mentioned, so, and we entirely accept that that is not a proper approach. We do say that that reflects what's interesting, therefore, about much of UIC's argument is where they start referring in terms of construction to forum, not to the DIFC courts being the more appropriate forum. There's a slightly odd attempt to essentially reintroduce forum convenience arguments through the back door of contractual construction. In terms of the discretionary remedies, clearly the court, and this is made clear under RDC 12.1, has a discretion not to exercise jurisdiction. I mentioned the Armco decision. It's obviously very well known. I don't know if your lordship is familiar with the core principles. Essentially, there was an allegation of a criminal conspiracy. Certain of the parties had entered an English exclusive jurisdiction clause, which the court declined to enforce because that would have meant that there would have been proceedings in New York and proceedings in England dealing with the same issue of whether there was a conspiracy in two different jurisdictions, with the obvious risk of an inconsistent judgment. That was, and so on that basis, the court declined, by making an antecedent injunction, to enforce the exclusive English jurisdiction agreements of certain of the defendants. Armco has been accepted and applied in the DIFC. I should say it's recognised at paragraph 160 in the IGPL decision, but it's also been applied in the Al-Kharafi decision. And there's reference in the DIFC court practice at page 24 to the application of the Armco jurisdiction. Happy to look at that. That's page 24.
Thank you.
The discretion of the court not to give effect to an opt-out. The court retains a discretion to refuse to enforce a jurisdiction agreement in favour of another court. Reference there to Al-Kharafi and Bank Saracen. Court of Appeal applied the English law approach set out in Donoghue and Armco, intended to prevent the fragmentation of litigation across a number of jurisdictions. The court should also give effect to a foreign jurisdiction agreement unless there's a strong cause not to do so. So that's very much a textbook application of the Armco principle.
Yes.
And thirdly, in terms of options, by way of discretionary remedy, we say lis alibi pendens as a collection of principles has obvious merits. As a matter of common law, it is intertwined, if you like, with the doctrine of forum conveniens. But if one looks at the principles, they do not, in terms of their logic and their principle, need to be entwined with foreign conveniens. We say that arises really as a matter of legal history. And if one looks at the sort of issues that the Chief Justice was considering in IGPL in deciding whether this discretionary controlling mechanism would work, we say lis alibi pendens does work. So if you've got a jurisdiction clause which provides, in a non-exclusive basis, for the onshore and offshore courts both to have jurisdiction, if one assumes, pursuant to goal, that a principle of election should apply, then lis alibi pendens has a number of merits. Firstly, it provides clarity. It's simple in terms of its application. Secondly, insofar as lis alibi pendens is a principle of both common law and civil law, it provides commonality in approach. So your lordship will be familiar perhaps with the Brussels Convention and the application of lis alibi pendens within the predominantly civil law jurisdictions of the European Union. Thirdly, it doesn't produce a void. There's no risk of essentially a case falling between the various jurisdictions where neither is exercising jurisdiction. Fourthly, it preserves the discretion of the court. And we say the value of it is that it operates before a conflict of jurisdiction has crystallized. So to that extent, we say there is no offence to the Article 199 jurisdiction of the UAE Constitution. Essentially, one court is giving up jurisdiction in not exercising it before the conflict arises. And your lordship will be familiar with the case law, because I think your lordship decided Lacan and Lamia, which was the decision about Article 5 of Decree 19 of 2016 in respect to the JJC, and the fact that the JJC's jurisdiction only arises where there is a conflict, and your lordship applied the principles of conflict as it arises within private international law or the private international law of the UAE. That's to say, both courts must be either exercising or asserting jurisdiction, and there is no conflict until that moment of crystallization of conflict. So this will be a situation in which the DIFC court would be not exercising its jurisdiction before the relevant conflict has crystallized. So to that extent, we say there's no offence to Article 199 and the constitutional arrangements of the UAE. And to the extent that that conflicts, or may be said to conflict with some of what is said in a paragraph I read out of Chief Justice Wang in IGPL, we would politely and respectfully suggest that he's wrong, and we would wish to make that argument, pursue it, and if necessary, pursue it further. Fifthly, it adds a principal basis for the court's discretion. So your lordship will be familiar with the principle that the court has various discretions which are often said to be unfettered, but actually, given that this is an international commercial court, any unfettered discretion needs to be exercised on the basis of principle. And sixthly, it avoids the need for any assessment of appropriateness and abuse. So all those other discretionary relief require some form of intense judicial inquiry as to which is the more appropriate jurisdiction, or on the Australian test, which is a clearly inappropriate jurisdiction, or if it's abuse, whether something is being done abusively in terms of the dominant intention. The lis alibi pendens takes a technical approach, and albeit that historically it's been caught up in foreign non-convenience and it's been considered to be part of foreign non-convenience, as a body of principles, it is capable of being applied separately, and indeed has all of the merits that I've just described. In terms of the legal history of lis alibi pendens, your lordship has the Aberdeen Dava case. That's at J 1077, and if I could go straight to 1090.
Yes, I've got that. Thank you.
And then picking up at the bottom of 1090 at H, where a suit about a particular subject matter between a plaintiff and a defendant is already pending in a foreign court, which is a natural and appropriate forum for the resolution of the dispute between them. So that's where foreign convenience, unfortunately, entwines itself in the reasoning for the resolution of the dispute between them. And the defendant in the foreign suit seeks to institute as plaintiff an action in England about the same matter to which the person who's plaintiff in the foreign suit is made defendant. Then the additional inconvenience and expense, which must result from allowing two sets of legal proceedings to be pursued concurrently in two different countries where the same facts will be an issue and the testimony of the same witnesses required, can only be justified if the would-be plaintiff can establish objectively by cogent evidence that there is some personal or judicial advantage, judicial advantage that would be available to him only in the English action that is of such importance that it would cause injustice to deprive him of it. So we'd say foreign convenience is actually a very small part of the test as it's been applied. What is more important is this notion of, are there proceedings already pending? Do they raise the same issues? And would the claimant in the second proceedings, the new proceedings, be deprived of some juridical advantage if the court exercised discretion not to exercise or to stay the English proceedings pursuant to the principles of lis alibi pendens? Those principles have been developed throughout the common law world. Essentially, the inquiry is to whether the pending proceedings, the existing proceedings, are genuine or are designed solely to seize jurisdiction. and whether the pending proceedings have progressed to any material extent. One sees that from the de Dampierre decision, which is at J1106. And if I could pick up at 1122. At paragraph 478, the same principle is applicable whether or not there are other relevant proceedings already pending in the alternative forum, the Abu and Dava. However, the existence of such proceedings may, depending on the circumstances, be relevant to the inquiry. Sometimes they may be of no relevance at all. For example, if one party has commenced the proceedings for the purpose of demonstrating the existence of a competing jurisdiction, or the proceedings have not passed beyond the stage of initiating process. But if, for example, genuine proceedings have been started and have not merely been started, but have developed to a stage where they've had some impact on the dispute between the parties, especially if such impact is likely to have a continuing effect, then this may be a relevant factor to be taken into account when considering whether the foreign jurisdiction provides the appropriate forum for the resolution of disputes between the parties. So there we see the issues of genuineness and whether the proceedings have progressed. So an issue of maturity, if you like, of the pending proceedings. And obviously, reflecting on the facts in our own case, we say that the case has been pleaded. We now have experts appointed. They will report. They will provide a report in February, and the matter will then be determined in the Sharjah courts. It cannot be said that we're just at the point of having initiating process. There is a further element which has developed in more recent cases as to whether there's any prospect of the pending proceedings being stayed. And again, pausing there, we've seen that there has been an application for a stay of the Sharjah proceedings, and implicitly the Sharjah court has proceeded and rejected that application in the Sharjah proceedings for a stay. In terms of this further principle, if one looks at the FNBB case at 1125, First National Bank of Boston against UBS, and if I could go straight on to 1130. Picking up the penultimate paragraph. Finally, it was in effect UBS who were the first to issue proceedings in this case, and that was in Geneva. They did not do so by way of riposte to anything done by FNBB. On the contrary, the writ issued by FNBB here was clearly in the nature of a riposte. So although I do not rest my decision on this aspect, given the obvious and well-settled principle that it is undesirable for the same issues to be litigated concurrently in two jurisdictions, insofar as the considerations discussed in Spiliada have any relevance to this case, Switzerland is a wholly appropriate and on balance the most suitable forum. Pausing there, some doubt as to whether foreign convenience principles apply at all in the consideration of a lis alibi pendens issue. Of course, UBC could equally have sued FNBB in England, but on the facts, no one can criticize them for having chosen Geneva. In addition to all these matters, it's necessary to bear in mind that certain further matters concerning the relevance, or should I say total irrelevance, of the English proceedings from the point of view of Swiss law. First, Swiss law has no doctrine of foreign convenience. Given the fact that FNBB carry on business and have attachable assets in Geneva, the court in Geneva must exercise jurisdiction if called upon to do so, even if, as here, not the case, England were the more suitable forum. Secondly, although Swiss law recognises the doctrine of lis alibi pendens, it is clear on the evidence that there would be no question of Geneva proceedings having stayed, even if FNBB's claim against UBS in England were to proceed. The reason is that the Swiss courts would neither recognise nor enforce an English judgment against UBS in the circumstances of this case. Finally, and of great practical importance, there's the fact that the Swiss action will go on whatever may happen in England. And if UBS succeed in obtaining judgment, then the sequestrated assets will be there and immediately available to satisfy judgment. There will be no need for UBS to come to the English courts or to go elsewhere to enforce the judgment. So the Swiss proceedings were first in time. They will proceed because even if the English courts were the foreign convenience, Swiss law doesn't recognise that doctrine. And just picking up on the final sentence of the following paragraph, whatever happens here, UBS can simply go on in Geneva, a natural and suitable forum, and no one could criticise them for taking this attitude. And then if we could just pick up at 1136. Second paragraph, in my view, the present case is a blatant example of such an attempt to allow FNBB's claim for a declaration of non-liability to proceed against UBS would be contrary to the spirit of comity between our courts and the Swiss courts. In all the circumstances, I have no hesitation in concluding that this is an abusive process of our courts. Accordingly, I would allow this appeal. So 2 points there. Firstly, the obvious similarity between the circumstances in that case, where the English courts have real concerns as to comity in being asked to continue the English proceedings. Secondly, that although the debate is framed in terms of lis alibi pendens in the earlier section, in terms of the final analysis of the court, it was in terms of abuse of process, and I'll pick up on this later. But essentially, the point is that even if your lordship is unhappy because it's a matter of legal history, lis alibi pendens is entwined with the doctrine of forum non conveniens. The same principles apply in terms of the discretion of the court to strike out what is an abuse of the process of our courts, in this case, the DRC court. And interestingly, the analysis in terms of whether the genuineness of the pending proceedings is in terms of one proceedings being a riposte to the other. So the court is trying to assess which is the genuine claim and which is just a riposte in terms of seeking to wrest jurisdiction into another court. We say this reflects the approach of the court in this case reflects a wider discretion in the Armed Code, whereas the court is astute to avoid a multiplicity of proceedings wherever it can do, in that case by not enforcing an English exclusive jurisdiction clause, where it was clear that the New York proceedings would in any event continue. By way of completeness, the lis alibi pendens principles have been widely adopted in the Australian jurisdiction. Your Lordship may be aware of the High Court's decision in Voth and Manildra Flour Mills. We have that at J 1190. This on its face is obviously a decision about forum non-conveniens as it's applied in Australia, and whether the test is spiliada or whether the test is a clearly inappropriate forum, which is obviously a much more stringent test in terms of staying your own proceedings. The DRC court considered this these Australian authorities in its own decisions in preferring the spiliada approach, and that's dealt with in the DRC court practice at page 14. But essentially, if I can pick up at 1203.
Yes, I have that. Thank you.
So just picking up over the page before, paragraph 30. So the previous decision is in a case called the Oceanic Sun. Before we refer to the judgments of the majority in Oceanic Sun, we should state very briefly what we take to be the common ground between them. So first, a plaintiff who has regularly invoked the jurisdiction of a court has a prima facie right to insist upon its exercise. Secondly, the traditional power to stay proceedings which have been regularly commenced on inappropriate foreign grounds is to be exercised in accordance with the general principle empowering a court to dismiss or stay proceedings which are oppressive, vexatious, or abusive process. And the rationale for the exercise of the power to stay is the avoidance of injustice between the parties in the particular case. Thirdly, the mere fact that a balance of convenience favours one jurisdiction or that some other jurisdiction would provide a more appropriate forum does not justify the dismissal of the action or the grant of a stay. So the prima facie of a right of a plaintiff to have their case determined means that the Australian courts are reluctant to apply foreign convenience and will only apply it where it's clearly the Australian jurisdiction is clearly inappropriate, and that is explained on the basis that a court will only dismiss proceedings which it has jurisdiction where those proceedings are oppressive, vexatious, or abusive process. So it's a relatively high test. But what the test that's lurking behind foreign convenience and the test that militated the choice of a more stringent requirement of foreign convenience is because the test is one of oppression, vexation, or abusive process, and it's out of that concern, the avoidance of injustice, that lis alibi pendens is then drawn out, if you like, in the Henry and Henry case, a family decision, which we have at 1165. And if I can go straight to 1182. Actually, if I can start over page at page 1183, the first new sentence. There are more compelling considerations in favour of a stay of the local proceedings if, as can happen, there are proceedings in another country which has jurisdiction to entertain those proceedings, and the proceedings are between the same parties and with respect to the same issues or controversy. And then 34, identification of the Union Steamship decision. And picking up at 35, it is prima facie vexatious and oppressive in the strict sense of those terms to commence a second or subsequent action in the courts of this country if an action is already pending with respect to the matter in issue. And there are cases in which it's been held that it's not prima facie vexatious in the strict sense of the word to bring proceedings in different countries. The problems which arise if the identical issues or the same controversies to be litigated in different countries which have jurisdiction with respect to the matter are such, in our view, that prima facie the continuation of one or the other should be seen as vexatious or oppressive within the Voss sense of those words. So going back to the general test of oppression and vexation in Voss, in the Voss case, and finding that it's prima facie vexation oppressive for a court for new proceedings to be brought where there are existing proceedings on the same issues in another jurisdiction. And then at 36, it doesn't follow because one or other of the proceedings is prima facie vexatious or oppressive within the Voss sense of those words, the local proceeding should be stayed. However, it does follow that the fact that there are, or even that there may be, simultaneous proceedings in different countries with respect to the same controversy is highly relevant to the question whether the local proceedings are oppressive in the sense of seriously and unfairly burdensome, prejudicial, or damaging, or vexatious in the sense of productive of serious and unjustified trouble and harassment. And it follows that the court should strive, to the extent Voss permits, to avoid that situation. So we say if the test is one of whether the new proceedings are seriously and unfairly burdensome, prejudicial, or damaging, or vexatious, we say they are. And if we seek, therefore, to apply the lis alibi pendent principles, the following factors are relevant. Firstly, the charge proceedings are on foot. They've been pleaded and experts have been appointed. The UIC, the insurer, has substantially participated in the charge proceedings, which are ongoing and which have not been stayed. They filed a counterclaim in the IDRC for the cancellation of the policy. They sought time for a defence in the charge proceedings. We know that the charge proceedings will proceed to judgment, and indeed the experts appointed on Monday will be reporting in February. There is clear jurisdiction under Article 37 of the Civil Code, and the insured IPMR does not even have the option of discontinuing, because if it did, the IDRC decision dismissing its complaint would then be enforceable as a matter of UAE law. So we're in a position of near inevitability, if matters proceed in both courts, that there will be parallel proceedings with a high risk, we would say, of inconsistent judgments. And in all of those circumstances, we say it would be vexatious and oppressive in the sense of seriously and unfairly burdensome for matters to proceed in both sets of court. Now, I entirely accept that I'm, to some extent, running in the face of Chief Justice Wang in IGPL, where he says that the parties have themselves to blame for their own misfortune. In my submission, that is an unduly harsh approach, and that the parties in this case have used a jurisdiction clause that is routinely used onshore in terms of insurance business and has been routinely applied. They should not be punished, if you like, by having to either run two sets of proceedings or run two sets of proceedings until both courts have exercised or asserted jurisdiction and then be required to take matters to the Union Supreme Court. There is no juridical advantage in the DIFC proceedings, which means that the UIC should be deprived of those advantages, should not be deprived in our submission. this is an obvious case for the application of a stay on lis alibi pendens principles. If your lordship isn't with me on that, then we say as is clear in the Henry case, the doctrine of abuse of process, and indeed the Voth case, the doctrine of abuse of process is available to the court under RDC 416(2), which permits the court to strike out proceedings where there is an abuse of process. We say the abuse of process in this case is, firstly, the offence to public policy, which has, in the onshore UAE, established a dispute resolution regime which restricts entitlement to issue to insureds, and that what would emerge if the DRC proceedings were allowed to continue would fly in the face of that public policy, and indeed would put the insurer in a preferable position. And that's the vice, if you like, of the decision of Justice Giles in the Buhera case of first instance. It would, if you like, turn the onshore dispute resolution on its head and produce a regime that would actually therefore favour the insurer over the insured, which in our submission is clearly contrary to the public policy of the UAE in establishing the separate regulatory and dispute resolution regime. Secondly, an attempt to derail the Sharjah proceedings, and we say without embarrassment that is what the DFC proceedings are, would significantly increase the costs. In the real world, we're all aware that claims have settlement value, and the more difficulty one can throw in the way of a claim inevitably impacts on the settlement value. And we say the DRC proceedings as an obstacle, as an additional element of costs, are part of a cynical ploy on the part of the insurer. There are obvious parallel similarities with other cases of abuse where, for example, there are multiple proceedings. So abuse of process is commonly found where there is Henderson and Henderson issue estoppel, or where there's a collateral attack on an existing judgment. All of those are instances of multiple proceedings where the court uses its power to strike out, its discretion to strike out for abuse of process as a means of preventing multiple proceedings with all of the additional cost and the risk of inconsistency between judgments that produces. And we say that the abuse of process doctrine is wide enough for the court to consider whether there is an abuse of intention. And in those circumstances, we say the court should take a robust approach under 416(2) in striking out. I should say, by way of postscript, that in Al Buhera at 1255, there was consideration of the abuse of process principle. As your lordship will be aware, abuse of process, or the findings of abuse of process, have not been appealed, or rather they were sought to be appealed, but permission wasn't granted. That doesn't preclude IPMR raising abuse of process in the facts of that case, because we say it's a discretionary remedy on the particular circumstances in the case. Essentially what was found by Mr. Justice Giles in Buhera was that the IDRC complaint was not a judicial process. So he was saying, insofar as abuse of process raises lis alibi pendens principles, there is no lis pendens because the IDRC complaint didn't constitute a lis. Now, obviously, we can distinguish our case because we are beyond the stage of the IDRC complaint. We are now into the de novo review of the IDRC's dismissal of that complaint in the Sharjah courts. So, in contradistinction to that case, there is in our case clearly a lis alibi pendens. Secondly, it was found by Mr. Justice Giles that the DRC court was a competent court under Article 110 of the insurance law. That, we say, is simply wrong, because in that case, the proceedings in the DRC court were not under Article 110. They were not a challenge, and that's self-evidently because the IDRC hadn't in fact formed a view, so there couldn't be a challenge to a decision that the IDRC had yet to make. In our case, similarly, Article 110 doesn't apply, and therefore the DRC courts cannot be the competent courts for purposes of Article 110, because UIC is self-evidently not appealing the decision of the IDRC that was in its favour. And lastly, there is Mr. Justice Giles found there was no real risk of an inconsistent decision, and that, in my submission, is a finding that has no basis. Clearly, in that decision, and as clearly, more clearly, in our case, we say there is an obvious risk of an inconsistent decision. So, for those reasons, we say that the primary relief sought is that there is no choice of the DFC court, and there should be a declaration that the court has no jurisdiction. And we accept the fact that your decision on that will be largely guided by the decision and reasoning of the Court of Appeal. If your lordship finds that, or is compelled to find that the DFC court does have jurisdiction, we say it can still stay the DFC proceedings by reference to lis alibi pendens and decline to exercise jurisdiction under RDC 12.1. Alternatively, if your lordship considers whether for lis alibi pendens type reasoning or other reasoning that the proceedings are abusive, they can be struck out as such under RDC 416.2.
Thank you, Mr. Reid. I have two questions. The first is, assuming the court does have jurisdiction, and assuming the court, as you submit, contrary to IGPL, does have a discretion to decline to exercise that jurisdiction by reference to any of the matters that you've just referred to, and the court declines to exercise that jurisdiction to decline to exercise jurisdiction, in other words, the court decides, no, we'll press on, then your remedy would lie with the Union Supreme Court under Article 9 of the Constitution, wouldn't it?
A view would have to be taken as to whether both courts had asserted or exercised jurisdiction, assuming that your lordship...
Clearly, Sharjah Court is exercising jurisdiction, it seems, from what was decided on Monday.
Yeah, I mean, the difficulty is if the decision was a decision, well, so the
scenario is, yes, the court has jurisdiction. Yes, we have a discretion not to exercise that jurisdiction, but we're going to press on anyway. You would then be able to go to the Union Supreme Court, wouldn't you? Because then you'd have two UAE courts both exercising jurisdiction over the same dispute.
Yes, I suppose the caveat to the rider, the wrinkle to that is that you may need to have, there may need to be, I'm not sure if there's authority on this, you may need to have appellate confirmation as a final decision by...
Yeah. Well, my question then is, if there is a discretion, should this court look to the principles that would be applied by the USC in resolving conflicts of jurisdiction between the UAE courts in the exercise of that discretion? In other words, should this court say, well, if we decide not to exercise the discretion to grant a stay and press on, then, and if there has to be appellate confirmation of that, and then if that is confirmed, and then it goes to the USC, should we look at what principles would be applied by the USC so that we can save the parties all that trouble in the exercise of the discretion? So in other words, if we could say, if this court could arrive at the conclusion that if the matter was referred to the USC would very likely determine that the courts of Sharjah should proceed, then would that be a factor in the exercise of the discretion?
Well, I'm obviously going to say yes, my lord.
Well, then I don't have any information about what principles the USC applies in resolving matters of this kind.
Well, except that I would say that the USC would be likely to apply UAE law, and that would be an application of the federal insurance law. And and when one looks at the constitutional division between the insurance regulatory and dispute resolution regimes, when one looks at that separation that exists as a matter of UAE law, both constitutional and federal, in terms of the free zone law and the federal insurance law, pursuant to the jurisdiction under the Constitution, the federal jurisdiction to decide those issues. When one then looks at the insurance law and the regime that's set up for the IDRC, to be subject to challenge in the home courts of the insured, and one then looks at the Civil Procedure Code, which simply provides for that jurisdictional provision, we say that is the route by which your lordship determines what the Union Supreme Court would be likely to do, because we say that regime exists as a matter of UAE constitutional law and as a matter of UAE federal law.
Yes, all right. My last question is, if we get into the area of the stay, just in terms of the nature of the stay, I assume you're talking about an indefinite stay, but with liberty to apply.
Lord, yes, and for the reasons your lordship set out in Sadia and Khatib 2021 CFI 099, 14th of June 2022, where you said that a stay was more appropriate than a dismissal because the court of the agreed jurisdiction may decline jurisdiction. So if for whatever, I mean, there's a notional possibility.
If Court of Sharjah is saying, oh, look, there's the stay application there, we'd better grant that, then...
Exactly. Then, as your lordship found, 5A3 could then be invoked to re-enliven, to use a phrase, the jurisdiction of the GFC courts.
Yes, right.
So, that's paragraph 3 and paragraph 137 of your lordship's judgment in the Sadia case.
Yeah. Thank you. Well, they're the only questions I had. It's obviously a good time for a break now. I'm up for bids, gentlemen, as to how long you'd like. Anywhere between 15 and 30 minutes. I'm up for bidding. What, Mr. Craig? How long would you like to have a break before we start again?
So, my lord, I made one error.
Yes, sorry, Mr. Reid.
The committee's reporting back in March and not February, so I apologise.
So I thought that would be extraordinarily expeditious, and they seem very modest too. They're going to do it all for 30,000 dirham, which obviously not lawyers.
Sorry, and the point of UAE law that I raised is, as a matter of UAE law, to go to the Union Supreme Court, you need a cassation judgment.
Cassation. So in other words,
within the UAE system, you need to have gone up to the top in the federal system. Right. And there may be some implication that you'd need to do the same in the. So
you'd have to do the same in Sharjah. You'd have to do the same in Sharjah.
My lord, yes. So that's the degree of cost involved.
Yes.
And I speculate, and I accept I'm doing that on the other side, in the offshore side, in the DFC, you may need an appellate decision. But I'm speculating by inference from what appears to be the UAE law position.
Yes, all right. Thank you for that.
Mr. Craig, how long?
Yes.
Mr. Craig,
how long would you like to break for, gentlemen? Mr. Craig, I think you're in the chair, really. So how long would you like to break?
15 minutes is fine. I mean, I don't think I'm going to be terribly long, to be honest, on my submissions.
Right. Mr. Reid and Mr. Hogan, is 15 minutes okay at your end?
Well, Lord, yes. Can we say 20 past the hour?
20 past the hour. Let's resume at 20 past the hour. Let's leave the links open in case there's any technical issues, but turn screens and sound off, and we'll resume at 20 past the hour. Thank you.
Thank you.
Thank you, Your Honour. Before I deal with the two questions which arise, I just want to correct 3 factual matters to the extent that they're relevant or matter. The first is the suggestion that the IDRC dismissed the complaint solely on the basis of procedural error by reason of the absence of an expert report. That's not correct. The IDRC dismissed the complaint because the defendant failed to submit the expert report and to prove its case. And the reference for that is B tab 8, page 349. The second factual point is that it was suggested that somehow the loss adjusters were
just before you leave that, given that the proceedings in Sharjah are de novo, does it matter why the IDRC dismissed it? Probably doesn't, does it?
It doesn't, no.
No, all right, thank you.
No, it was just there are certain things I just wanted to make it clear. The suggestion that the loss adjusters CTA are somehow satisfied this is a bona fide claim, that's not correct. There are subsequent reports apart from anything else, and as you know, the basis of our claim is in fraudulent misrepresentation, etc., for various reasons. I don't need to take you there.
Well, those are matters to do with the merits, which I'm not concerned with.
Correct. Yeah. And then the third point that was made was about Chedid Re being a Lebanese entity. It is in fact an FCA registered insurance broker in London, and it can only place risks at Lloyd's in London because it is so registered. Right. So that Lebanese point, it goes nowhere.
Yes. Right. Thank you.
So that then leads me to deal first of all with the question of jurisdiction and then with the stay. And as you know, it turns on whether or not the jurisdiction agreement in the policy satisfies the requirements of Article 5A2 of the Judicial Authority Law. This is something for me of a Groundhog Day.
Yes, I'm sure.
Given, first of all, the first instance before Justice Roger Giles and also the Court of Appeal. But if I can ask you, you've looked at the jurisdiction agreement and the phrase each party agrees to submit to the exclusive jurisdiction of the courts of the UAE, which is in the gold refinery policy at B tab 8, page 229. And as you know, and I don't want to sort of take over ground you're already fully familiar with, but a clause in identical terms was considered by Justice Roger Giles in Al Bahara. And if I could just ask you to look at that judgment, it is bundle tab J, tab 63, page 1248 is where it starts.
Yes.
And you will see at paragraph 6, overleaf page 1249, a clause in effectively identical terms to the one we are considering here. You will see, first of all, provides for governed by English law. This each party agrees to submit to the exclusive jurisdiction of the courts of the UAE, which is obviously the same terms we have here. Now, there were 2 points taken, here by IPMR as to why it said that expression, courts of the UAE, does not include the DIFC courts. The first is the said lack of connection to the DIFC for any of the parties, and the second is the alleged context of the insurance law. Now, as you know, those points were taken by the defendant in Al Bahar, exactly the same points, and they were roundly rejected. And as regards the lack of connection, paragraph 14, you will see at page 1250, you'll see the submission that was made was there was a complete lack of substantive link to the policies and the DFC or even Dubai, etc. And then at paragraph 16, a link to the DIFC is not necessary for an agreement as referred to in Article 5A2. That's the point of an opt-in, common for parties to submit their disputes to, for example, the commercial court, even if there be no connection with the country. Does not exclude regard to presence or absence of a link in the task of construction, but the absence of a link is of itself of little significance. And just pausing there, that part of the decision was not the subject of appeal.
Yes.
And I would say that that submission that was made this morning about the absence of a connection is not well made. As regards the impact of the insurance law, you will see that in the judgment starts at paragraph 20, which is at page 1251.
Yes.
And you will see it talks about the seconds of the submission being rather protean, but took shape at the hearing. It said ABNIC's insurance activities were subject to the insurance law and the dispute resolution procedure in its Article 110. And then it talks about the argument that was advanced. And then at paragraph 21, you will see his finding. I'll refer in more detail to the insurance law in connection with the abusive process. As there explained, the dispute resolution procedure deals only with an insured taking a complaint to the insurance authority and even as to such a complaint provides to a challenge to go to the competent court of first instance. This is not limited to the onshore courts. It is open to the parties to choose their court or courts of competent jurisdiction, and I see little weight in this in excluding the offshore courts from their choice. And then in paragraph 22, you will see he says the submission included DIFC courts could not receive a challenge because by force of Article 4.4, a DFSA authorised company conducting insurance activities was restricted to reinsurance business. As I best understand the argument, it was said the exclusion of other insurance business from the DFC evidence the policy, regulation and enforcement, etc. be excluded, with the result that DFC courts could not hear a dispute arising under or in relation to insurance, onshore insurance. And then paragraph 23 talks about the confusion with the difficulty in the argument. It's enough. I'm unable to see the restriction on insurance business in or from the DIFC has any bearing of the ability of the DIFC courts to hear insurance disputes if the parties to the insurance contract agree that it can do so. And just to make good this point about the insurance law, paragraph 37, which is at page 1254.
Yes.
And you'll see that the allegation about the abusive process, and one was that there was an abusive process for ABNIC to seek to sidestep and evade the application of the dispute resolution regime imposed by the insurance law. And then paragraph 38, critical to the first of these is whether Article 110 precludes ABNIC from bringing the proceedings. Horizon contended, ABNIC didn't contend otherwise, insurance activities were subject to the insurance law. But Article 110 is confined in its operation. The terms of the clauses suggest it's only the insured who can make a complaint, and this is made clear in the authority decision pursuant to clause 5 of the article as regards its competencies. And then you will see at paragraph 41, for whatever reason, perhaps because declaratory relief and claims by insurers for negative declarations are not ordinarily available in the civil courts, dispute resolution regime under Article 110 regulates only complaints by an insured against an insurer. The restriction in clause 3 of the article on accepting claims precludes a court from accepting a claim, can only apply to claims against the insurer. It follows ABNIC is not acting contrary to the dispute resolution procedure in Article 110. And then it should still be asked whether, although ABNIC is not acting contrary to the dispute resolution procedure in Article 110, it can be found in the regime that it is to cover the field. So the only way an insurance dispute can be settled is by a complaint by the insured, that it is not open to the insurer to initiate any form of dispute resolution procedure, including bringing proceedings. Nothing in the article so provides, and it's evident the regime does not cover the field from the provision in Article 6 that the committee shall not be competent in relation to insurance disputes subject to an arbitration clause. That is, the parties are left to agree upon other means of resolving disputes between them. Now, there was no dispute, and there is no dispute that the dispute resolution procedure under Article 110 regulates only complaints made by an insured. It does not provide a forum for the claims of insurers. And we say that of itself is fatal to the defendant's submissions and its application on jurisdiction. Now, at the appeal hearing in Al Bahara on Monday, the appellant contended that an insurer had no right to bring any claim itself under the insurance law and had to wait for such to be brought by an insured. Now, we submitted that what is fatal to that submission is it would mean that an insurer could never start proceedings to recover, for example, premium. Because there may not be a claim, but it is not paid. it's not being paid for its for the cover it's
Mr.
providing.
Reid, I think you should perhaps go on mute. I think. Yes, thank you. Yes, Mr. Craig.
Thank you. And it appears that IPM are adopting the same argument on this application. We also dispute the claim that Article 110 provides a complete code for dispute resolution. We say, and we said in the Court of Appeal, that it's not even mandatory for the insured to pursue it. Now, I don't know how much detail you want me to get into in relation to Article 110. I'm sort of in your hands, but what I would say is effectively this part of the case is really going to be determined by what the Court of Appeal says.
And that's what that sounds like what I said about 2 hours ago.
Yeah, it's quite. Well, that's why I'm just trying to.
I'm in your hands, but I think it would be a brave judge, and I'm not one of them, to go against the decision of the Court of Appeal as soon as it's handed down. Well, I'm not ruling anything out, but it seems unlikely.
But I'm grateful. I mean, I thought it was important just to set the scene effectively for what it is that was being determined by Justice Roger Giles. And if you're happy to go any further, that effectively, I mean, as I said in my skeleton, to the extent that they're relying upon the insurance law as a means to say, well, this jurisdiction agreement can't confer jurisdiction on this court. Well, that's what's before the Court of Appeal effectively.
Yes. Well, if the Court of Appeal leaves any doors open, then of course it'll be open to either party to come back and say, well, it doesn't resolve that first issue in this case for this reason.
Yes. Well, you're quite. So I'm not going to waste your time any further on that. Unless there's anything particularly you'd like me to deal with that was raised.
No, that's fine. Thank you.
Now, turning to the application to strike out or stay the claim on the grounds of Liz alibi pendens, I make 3 points. First, the concept of Liz alibi pendens has no application on an intra-UAE basis. Secondly, if it does have any application, the relevant question is not which proceedings were commenced first in time, but which is the more appropriate, having regard in particular to any particular personal and juridical advantages. And then thirdly, on any view, nothing that UIC has done can possibly be regarded as abusive so as to justify a stay.
Yes.
Now, dealing with the first point, that Liz alibi pendens is not of application on an intra-UAE basis, it is accepted by the defendant and was repeated again in submission this morning that Liz alibi pendens is understood as forming part of the common law concept of forum non-conveniens. And obviously, and you were taken to it, in IGPL, it was held that forum conveniens should not be applied on an intra-UAE basis. Now, also in IGPL, as stated in our skeleton at paragraph 33b, Liz pendens and risk of conflicting judgments are regarded as but two of many factors which determine the suitability of permitting an action to subsist in a particular forum. So in this court, it regards, we say, Liz pendens as part of the forum non-conveniens principles. And I take you to that particular part of the judgment. It's tab J, tab 55, page 1071.
Yes, I have it then.
Apologies, my computer is a little slow. I'm almost there. At paragraph 171, you will see the reference to Liz Pendens, and the risk of conflicting judgments are but two of many factors which determine the suitability of permitting an action to subsist in a particular forum. And that refers to other potential factors. Now, the fact that there might, in consequence, be two sets of proceedings running in parallel within the UAE is of itself, we say, irrelevant. And if I could ask you to look at the decision of Allianz, first of all, which is bundle M, tab 74, page 1659. And just so we're clear on what happened in this case, first of all, Allianz started proceedings in the DIFC court under a contract of reinsurance. The defendant, a few months later, commenced a claim in the Abu Dhabi courts. So you had two simultaneous proceedings. And the defendant also applied in the DIFC court for an order that it had no jurisdiction on grounds that it was an Abu Dhabi domiciled entity subject to the provisions of the CPL, and had lodged a petition with the USC, which has exclusive jurisdiction to hear claims arising out of the conflict of jurisdiction. And so then the defendant applied for a stay of the DIFC court proceedings. And if I could ask you to pick up the judgment at paragraph 29. It is page...
Yes, I've got that, thank you.
Yes. The first point is it makes clear that it is clear to the court that before taking a purported jurisdictional conflict to the USC for its consideration, there would first have to be two conflicting judgments over a jurisdictional matter issued by different courts in the Emirates. Secondly, more importantly, these conflicting judgments should be final. In other words, the USC's jurisdiction would start after two UAE courts had issued two judgments creating a positive, both claiming jurisdiction, or negative, both declining jurisdiction, conflict of jurisdiction, which cannot be said to happen until each court has made a final decision in that regard. In that event, those two judges will be questioned before the USC, but not the parties' submissions or arguments before final judgment has been delivered by the conflicting courts. And then paragraph 30 refers effectively to the fact that the application by the defendant is premature because the USC says applying up to the defence application can be seen as the timing, development, progression of the case, assumption there might be jurisdiction for an Abu Dhabi court to deal with a substantial case to take the conflict before the USC is premature. Therefore, the court takes the view the grounds put forward by the defendant for this court to use its power to stay the proceedings are not realistic or even helpful. Court rejects the application for order to stay and shall continue to deal with the alternative relief sought by the defendant in their following paragraphs. And then at paragraph 31, you see, as regards the argument of the defendant that to allow both proceedings to continue would mean the parties incurring the costs of parallel proceedings. I agree with the defendant's position and add to it that there will be the cost of the petition before the USC. Though it is not an ideal way to resolve jurisdictional conflicts, we are not in a position to review the legal system in the UAE or to suggest a better way of dealing with such a matter. However, I will refer to this as a risk both parties have brought onto themselves when failing to agree on a jurisdiction clause in their sophisticated contract, or even to reach an agreement at any stage after the dispute had arisen, knowing full well the legal system in place in the UAE. Now,
Mr. Reid submits that the court has a discretion to not exercise jurisdiction by virtue of RDC 12.1. Well, first of all, do you accept that, or do you not accept that?
I don't accept that. Not when it comes to an intra UAE court, because that dispute can only be resolved by the USC. And just pausing there, this court doesn't have the power or the tools, as it were, to carry out that exercise. That is only for the USC.
Yes, all right, thank you.
And then if we could look at, apologies, going back to the decision in IGPL, which is tab J55, and it is in particular 1074. And forgive me a second while I just scroll to the page.
Thank you.
And you will see it, paragraph 188. The paragraph 186, it's not disputed by the parties. Power to determine jurisdictional conflicts is vested in the USC. Then at paragraph 187, although Article 99 does not adopt the language of exclusive jurisdiction, cannot be understood as conferring on the USC anything less than exclusive jurisdiction over the matters set out in that provision. Any other interpretation would make a nonsense of the USC's primacy in the UAE's judicial hierarchy by permitting other UAE courts to preempt or supplant the USC's decisions on matters it is charged with hearing. So that goes to the point about whether or not you can hear this.
Well, you submit that it would be wrong in principle to try and speculate about what the USC court would do if the matter was referred to it.
Correct.
This court would be effectively usurping the USC's jurisdiction.
Precisely.
Yes, all right.
And then paragraph 188, as against this, IGPL's reliance on the example of England, Wales and Scotland provides no answer. That example is an inappropriate comparator because the UK does not adopt an overarching mechanism, constitutional or otherwise, to resolve a jurisdictional conflict. And then it says, once it is appreciated the power to determine the appropriateness of a UAE court's assumption of jurisdiction relative to other UAE courts rests exclusively with the USC, it cannot be persuasively argued that the DFC courts have any power to determine the same question by applying the FNC question. Doing so would be amount to a usurpation. So it's the same point, basically. You can't usurp that function. 190, it's true a jurisdictional conflict crystallizes and the USC intervenes only after the competing UAE courts issue conflicting and final judgments on jurisdiction. But that fact does not mean the DIFC can apply the FNC doctrine, and we would say similarly the Lis Pendens doctrine, before a jurisdictional conflict crystallizes, such as in the present case. The power to resolve jurisdictional conflicts is vested in the USC, absolutely. It is not conditional on the occurrence of an event such as the crystallization of a jurisdictional conflict between the two UAE courts. This is unlike the USC's jurisdiction over inter-emirate disputes. And paragraph 191, the point is the power to determine jurisdictional conflicts is absolutely and exclusively vested in the USC under the UAE's constitution, is therefore removed from this court's power under all circumstances. So the point we make is, if this court does have jurisdiction, which we say it does, it's the point one, the fact that there are proceedings going on in another part of the UAE does not give this court the ability or the power to stay these proceedings in favour of those other proceedings. And just two points just to pick up. I mean, it was said in the skeleton that wasn't pushed in argument that RDC Rule 12.1 we made redundant if the court didn't have the ability to exercise discretion to grant a stay. But that doesn't take the matter really any further, because that rule, of course, is concerned with all situations. And of course, this court will apply the forum conveniens principles when, for example, it's comparing the jurisdiction of the DFC court as against, for example, a court in Lebanon or a court somewhere else outside. But this is very specific to what's happening intra-UAE. And then the second point is that the defendant seems to suggest that the federal courts apply some form of lis pendens themselves, some sort of discretionary remedy. Now, no attempt is made to identify what that doctrine is or how it is applied by the UAE federal courts. And it's plain that the UAE courts themselves do not regard jurisdiction as a discretionary matter. So therefore, why should this court? And we can see that, again, it's in IGPL, and it's at page 1047. And it's quoting the judgment of Justice Sir David Steele at paragraph 36B.
Yes, I've got it. Thank you.
Yes, and you see the UAE courts, in line with its civil law roots, would not regard jurisdiction as exercised as a discretionary matter. And you're being asked here to exercise a discretionary view by staying the proceedings. And I submit that's not appropriate in circumstances where you're looking at intra-UAE proceedings. An additional point is IPMR says it has no option but to pursue the claim in the Sharjah courts to ensure it doesn't lose its rights of recovery. Now, we don't accept that. First of all, a competent court for that challenge is also the DIFC. Secondly, it is implicit in the commencement of these proceedings by insurers that there is a dispute under the insurance policy, which, if UIC loses, will result in the payment of an indemnity to the defendant. So anyway, that deals with the first point. Stay is not available as between the intra-UAE. The second point is, if you're not with me on lis pendens being of application or not of application on an intra-UAE basis, then we say, well, the effect of a lis pendens is not that the proceedings commenced second in time constitute an abuse. Rather, the first proceedings are simply part of, or potentially part of, the relevant inquiry as to which is the more appropriate forum. And we say that the proceedings in Sharjah are not very far advanced, so they're really irrelevant for the purposes of these proceedings. I mean, they were commenced literally a month apart. The only reason that we are, that they're perhaps a little more advanced than these proceedings is simply because of the jurisdiction challenge, which then slows things down, and the Sharjah court has acted potentially more rapidly.
But on the evidence, they're going to be resolved in March.
No, the experts will report back in March.
But have the experts been delegated with the power of decision, or is it a report back to the court and then the court reviews that report? How does it work? Do you know?
I think I would be guessing. I think it's more the latter. The experts report back to the court, and then the court decides whether it needs any more evidence. The parties can make further submissions, and the process continues. I mean, I think if there are any deficiencies, for example, in the reporting, then that can be further investigated. So there's not going to be a decision on the merits in March. I think it's fair to say. And I've identified in the skeleton, and I don't think there's really much to add to what I've said, and why we say there are juridical advantages available to this court which are not available in the courts in Sharjah. Now, that is not, as was suggested, to cast any aspersions on those courts at all. It is simply to say that in this court, there are tools available which are not available in the Sharjah courts, which we would like to take advantage of. And those are, in particular, the ability to obtain orders for the production of documents. And that, we say, is important in the context of a fraud case like this, or potential fraud case like this. And secondly, we can call experts with relevant expertise, independent experts who can give evidence to the court. Now, fully appreciate that the court in Sharjah has appointed 3 experts, 2 gold refinery and 1 insurance expert. However, as you identified, they're going to be paid a sum total of 30,000 dirham between them, which is a tiny amount of money, really, if you imagine what experts will charge to carry out a thorough job. And the second point is those are the experts that are on the Sharjah court roster. So they may not be the relevant independent and qualified experts that one really needs to get to the heart of this matter. And the final point is obviously the ability in this court to obtain declaratory relief. So that's all I want to say about the advantages, if you like, of this court as against Sharjah. And then finally, my third point, we say that it cannot be said that anything that the claimant has done in bringing these proceedings can possibly be regarded as abusive. Firstly, the parties agreed to confer jurisdiction on this court. That's obviously the assumption. That's only based on which one's considering this strikeout application. And it should not readily be found that invoking that jurisdiction that the parties have chosen is an abusive process. And I don't think we need to go back to it, but that's precisely what Justice Roger Giles said in Al-Bahira at paragraph 49. The second point, you were referred to the decision of the High Court of Australia in Voth, and it is at J tab 61, page 1190. And it was the passage at 1203. And it was, yeah, got that place. Yes, and you were taken to the first 2 points, but it was the final point of the paragraph in particular which I wanted to draw your attention to. Finally, the jurisdiction to grant a stay or dismiss the action is to be exercised with great care or extreme caution. Now, what I would say is you have to be very careful, obviously, before you say, well, yes, we're going to stay these proceedings. And dealing with the allegations of alleged abuse, the first point is the contention about the insurance law and that it is a code for dispute resolution. Well, we say that's wrong, but in a sense, that's going to be determined by what the Court of Appeal says. Yeah. The second point is that the IDRC decision and those proceedings have nothing to do with court proceedings that the parties choose to prosecute after a decision of the IDRC. Now, we fully accept that we participated in the IDRC process, but we had no option, or sorry, we couldn't not do so because once that procedure is started, then it's followed through. But that doesn't mean that the court proceedings have to take place wherever the IDRC committee is situated, or indeed where the insured is based. Now, these proceedings were commenced within a month of the proceedings in Sharjah being commenced, and at a point in time when nothing had really happened in the Sharjah courts. Now, the fact that proceedings are issued in 2 courts at once cannot of itself be regarded or described as abusive. It's also submitted that the start of these proceedings was a deliberate attempt to derail the Sharjah proceedings. Now, we say there is no basis for that submission in fact or law. And if you look at what actually happened, the proceedings in the Sharjah court were served on my clients at the end of August 2022. There was then a hearing listed within a very short space of time on the 5th of September. And bear in mind that my clients are fronting insurers for London market reinsurers. And of course, before it does anything, it will need to take instructions and work out what precisely is going to go on and what it can and can't do. And in those circumstances, a month to issue proceedings in the DIFC cannot possibly be regarded as something which is abusive or in any way in bad faith. And of course, there's no obligation for us to identify during the IDRC that we were going to start proceedings if necessary in the DIFC. That would be utterly irrelevant. And equally, during the hearings on the 5th of September and the 20th of September, we were first of all seeking a POA, and we couldn't say anything to the court until we had that POA. And on the 20th of September, filing an application for extension to file the defence. Again, there's nothing wrong with that, and it can't be said that that was done in bad faith. And if you look at it another way, what difference would it have made if we'd said, we're going to start proceedings in the DIFC court? Would have made absolutely no odds. So therefore, we say there is no abuse in any event. I'll just take instructions, but I think that concludes everything I need to say, unless there's something else you'd like me to assist you with.
No, thank you, Mr. Craig. That's been very helpful. You want a minute to get instructions?
I've had a WhatsApp saying all good, so thank you.
All right, thank you. Mr. Reid, reply.
My Lord, just a few points, if I may. In terms of the IDRC's dismissal of the complaint and the reasons for that, I would ask your Lordship to read B349. In my submission, in terms of the reasoning, as the committee says, we instructed them to file expert evidence. They haven't filed expert evidence. They haven't proved their case. And in my submission,
but how does it matter, Mr. Reid?
I agree, my Lord. I don't wish to be suggested I've misled you in any way, but that's all I have to say on that. In terms of the loss adjuster, at page 1564, it is there's reference.
Again, how does this matter? How does this matter to me? I'm not trying the case. I'm just deciding which court has jurisdiction.
Okay. And in terms of, well, I will just say that there's reference to the later loss adjusted reports, which are not exhibited, and the inference that's sought to be drawn is that they are somehow favourable to the insurer. But in my submission, that would be a bad inference.
Mr. Reid, I'm going to decide this case on the basis that there is a genuine dispute of fact between these parties, and it's not for me to assess any of the merits or demerits of that dispute.
My Lord, yes. My Lord, yes. And in terms of Shadid Re at 467, we have as with many, and one of many documents, we have the details of them. They are a company in Lebanon that operates as Lloyd's brokers. I refer to that simply as undermining the suggestion that you need to be English speaker steeped in common law in order to deal with Lloyd's and standard English insurance contracts and forms. That's simply isn't the case, and that obviously goes to the abuse and the lis alibi pendens point.
I'm sure Lloyd's policies are the subject of litigation in civil law countries all around the world.
My Lord, yes. And in terms of Al Buhaira, it is not binding. I accept that we collide in our submissions with some of the points taken by Mr. Justice Giles. He says if it's an opt-in, you don't need to look at the context. We say it's an exercise in construction, and context is obviously important in that. He says that Article 110 can be the DIFC court. We say that it's not Article 110 because it wasn't a challenge to the IDRC. He said that the regime only affected the insured. It doesn't bind the insurer. we say that simply doesn't make sense because it would mean that the regime, in fact, favoured the insurer, which we in our submission would be obviously wrong. So we accept that. I entirely accept that the decision, Mr. Justice Giles, is to some extent persuasive, but it's not binding. It is another decision at first instance. I've made my submissions in respect of lists, alibi, pendens. We say, as a matter of principle, it can be distinguished from forum non-convenience, albeit that as a matter of common law, the two have to some extent been intertwined. Will you excuse me? I'll just try to decipher my own notes.
Yes, certainly.
I think it was suggested that Buhera precludes the court exercising discretion under Article 12(1) in deciding whether it is to exercise jurisdiction. If the submission did go that far, we would point out that in Buhera, it was accepted that abuse of process was available as a discretion, albeit that the court in that case didn't find that there was an abuse of process. But it wasn't suggested that an argument of abuse of process was by itself precluded, and that no such argument could be raised because 12.1 did not allow a party to raise 12.1 in respect of an exercise.
I think the submission was put not so much in relation to abuse of process, but in answer to my question about discretion. And I think that was as far as the submission went.
Yes, but
the submission is that there is no discretion to be exercised. Mr. Craig, if I get this wrong, but as I understood the submission, it is that there is no discretion merely because there are two conflicting cases before UAE courts. That doesn't give rise to any discretion. Yes, that's
yes, which in my submission
is as far as to say there's no abuse of process power.
Okay, well, to that extent, I mean, I clearly accept that under IGPL, forum non-convenience as a grounds of discretion is not available, but we emphatically submit that 12.1 does still provide discretion not to exercise pursuant to other grounds, and you know, we've looked, for example, we looked at the ARMCO discretion, and to the extent that the court has discretion to strike out for abuse of process, we say that discretion remains available to the court. In terms of insurance disputes, and I apologise to my learned friend if I'm furthering his sense of Groundhog Day, but in respect to the issue of premiums, if one looks at Article 110 at page 848, and I apologise if I could just quickly go back to that. So the process is that the insurance company processes the claim, and then the insurance company issues a decision about the claim. If the claim is rejected, the company provides reasons. And then if a dispute arises in respect of the claim, and I say this is the insurance claim, the concerned parties will have the right to submit a written complaint and to ask for that to go to the, in a sense, to go to that to the IDRC. So we say on a proper construction of Article 110, one is dealing with the substance of the insurance claim, not with any related issues about whether a settlement was procured by fraud or whether premiums have been or have not been paid. Those would be separate disputes. They wouldn't come within Article 110 because they're not. Article 10 is about protecting the insured in terms of providing for them on their claim if their claim is rejected.
So that's how I'm clear. Are you saying that Article 110 doesn't cover the field of disputes between insurer and insured?
No, it
covers the field of claims.
My lord, yes. It's disputes arising from claims where the company has fully or partially rejected a claim. And to that extent...
Of course, in that context, it would be a nonsense for the insurer to instigate proceedings.
Well, yes, because if they've rejected the claim and if the IDRC then either the insured goes to the IDRC and seeks to challenge the rejection of the claim, or the rejection stands, in which case the insurer is sitting pretty.
Yes.
Then in terms of the Yes. Well, I've made the point already. I'll return to it. If the suggestion is made that the court usurps the Union Supreme Court jurisdiction, and we say the logic of that section in IGPL is that the jurisdiction does not arise, and this is parallel to the JJC jurisdiction, where there's been a reference under Decree 19, that jurisdiction until there is crystallized a conflict of jurisdiction. So to that extent, it doesn't usurp the Union Supreme Court jurisdiction. And I accept that there's a tension in what I say on that with some of what's said in.
You go further. You say that to the extent that your submissions are in conflict with IGPL is wrong, and you wish to preserve the capacity to make that submission on an appeal.
You have the point exactly. I'm grateful for your very pithy summary of our submission. The submission that the onshore courts do not decide on the exercise of jurisdiction as a discretionary matter was somewhat undermined by the fact that it is UIC in the Sharjah proceedings that has sought a stay by the Sharjah court. And I would urge caution if your lordship is minded to accept that submission. That clearly does not seem to be borne out by the facts of the case. In terms of the juridical advantage and the tools available, it is clear that the IDRC has very broad powers in terms of documents, witnesses, etc. It is also clear from the M 2004, that's to say the preliminary ruling of the Sharjah courts in terms of what the committee of experts can do. Clearly they have access to experts. In the real world, if they ask for documents and they're not provided, then that is extremely prejudicial to the party not providing. So there is de facto production of documents. And regardless of what as I think Mr. Craig, the learned friend, accepted, regardless of what the committee finds, the court isn't bound by its experts. The court then forms its own view. And clearly, if parties have declined to disclose documents, that will be very prejudicial to their case. Just one point of clarification. The experts come from the roster of the UAE Ministry of Justice. So it's not, I think it was suggested they came from the roster of the Sharjah courts. So they are not even necessarily in Sharjah. They are plainly, in our submission, independent, far more independent than the party-appointed experts that one finds in many common law proceedings. They have no axe to grind. They are appointed by the court. They're not beholden to any party. They're entirely independent of any party. So we would reject any submission that they are to any extent less than independent. So those are my only points of detail. And unless Mr. Hogan suggests otherwise, those are my reply submissions.
Well, thank you, gentlemen. We'll proceed in the way I indicated. And just in that regard, I've been thinking about this. I'm thinking it might be appropriate for me to make a direction along the lines that within 21 days after the publication of the decision of the Court of Appeal, the parties confer and then advise the court, confer with respect to the process that should be followed in relation to any further submissions dealing with these applications. And in the event of agreement, advise the court of that agreement, or in the event of lack of agreement, each party should provide the court with a minute of the directions that they seek in relation to that process. Would something along those lines be appropriate, do you think, gentlemen?
Could I just take instructions very quickly?
Yeah.
But my lord,
Yes.
Lord, yes.
21 days long enough? Is 21 days long enough, do you think?
I'm just taking instructions actually on this, but I mean, in my own view, 14 days should be sufficient. I mean, the judgment.
My only concern is I've got a number of trials coming up, and there is the Easter holidays coming up, so I would ask for 21.
Yeah.
We may be dancing on the head of a pin.
Aside from time, Mr. Craig, is there any other objection to a direction along those lines?
No, it seems to make sense. I mean, as I say, we will resist, obviously, a further hearing per se, but it may be that you be assisted by some. I mean, we'll see what the Court of Appeal says.
But it may be that Mr. Reid will fold his tent and go away. Well, no, you might, no, Mr. Craig, you might fold your tent and go away if the appeal succeeds. But otherwise,
my Lord, obviously, to the extent that a party,
secondly, sorry, Mr. Reid.
To the extent that a party seeks a hearing which your lordship ultimately considers to be unnecessary, that would sound in costs. So the parties have that discipline.
Of course. All right. Well, I'll fashion an order along those lines, and that'll issue. And otherwise, obviously, I'll reserve my decision until at least the decision of the Court of Appeal has been delivered, and until you've had an opportunity to put further submissions before me, well, hopefully in writing, but also if somebody can make out a case for further oral submissions, I'll hear those as well. Is there anything else, gentlemen?
My Lord, no.
Well, thank you very much, gentlemen, for the argument. It's very interesting, as always, and very well constructed, for which I'm grateful to not only those who presented it, but also those who stand behind the scenes and assist in its preparation and presentation. So thank you to all involved. And that concludes the hearing. The court will adjourn.
Thank you.
Thank you.